Hi, good morning. We're ready to start the call on the docket. You want to call it or you want me to? Well, I don't think they can hear you over there because of that. So. 2024 CR 19588, State versus Timothy Baxter.
Judge, I represent Mr. Baxter. That is going to be for plea today. If I could second call that, he had indicated that he was having car trouble.
Second call. 2023 CR 19378, State versus Fletcher Dale Bolling Jr.
Judge, I represented Mr. Bowling. That is going to be for, I think it's a restitution review.
All right. Looks like his last payment was $50 in restitution on the 13th of July. Mr. Bowling, is it Bowling or Bolling?
It's Bowling, B-O-L-L-I-N-G.
All right, Mr. Bowling, you are here today to review your restitution. It looks like on restitution you owe $2,500 and you paid $450. Is there a reason you're not able to pay more than that?
I'm not working right now, but my restitution is $6,544.
State have any position on this other than just to continue monitoring? I see the total assessed is $6,944, and of that I assume is court costs, fines.
This is not. It's been brought to my attention that maybe his social media posts show a lot of vacationing, and for someone who's unemployed and not paying restitution, that would seem to be opposite of what we're representing.
One of the things that you find out is when you go on vacation, post a bunch of stuff on your social media accounts that indicates that somebody's going to see that and know that about that. I don't care whether you go on vacation or not, as long as you're paying your restitution.
My honor, I have not been on vacation.
Okay.
I just got home 2 months ago from 11 months program.
Okay. You have anything that Mr. Bond to add?
Got 2 documents right here to show it where I've been.
All right. Well, you've made some payments. I'm just suggesting that it's going to take you a long time of paying $50 a month to be able to pay off a $6,000 or almost $7,000 fines and costs. So let's put him for a review. When am I back here again? November. We're going to have another review November 24th. That's going to give you about 4 months to see if you can make some headway on this. All right.
Okay. Do I still make the payment $50 a month?
Well, make more than $50 a month, but at minimum of $50 a month. So.
Okay.
More that you.
Thank you, Martin.
Let me put it this way. The more you can pay, the sooner you're going to be done with this having to appear in court all the time. Okay.
Okay.
All right. Thank you. 2026 CR 19853, State versus Charles Ronald Chambliss, public defender.
Judge, that was supposed to be for plea, just off of the last status date. I thought we could get it worked out. I haven't heard from Mr. Chambliss, but we haven't had any opportunity to go over his discovery. But maybe he's going to show up. But he was definitely here that day.
So what do you want to do with it? I mean, are we needing to set it for trial, or are we needing to set another status date?
Just another. Well, just another status day, but I would say.
You're saying he should have shown up and he needs to have his bond revoked?
That's what I'm saying. Of course,
obviously.
You're saying he should have shown up.
Well, yeah.
There's some sort of reason he's not here, and please don't revoke his bond.
That's kind of where I'm at, Judge.
I found like if I could just argue both sides of your motion.
Yeah. Well, you don't even need us.
Speeds things up. All right. Well, let's put it on a second call and see if you can find out where he is and why he's not here. And then if you're not going to be able to settle it, we'll put another status today. We'll put another status date, and then if that doesn't work, we'll set him for trial.
Perfect. Thanks, guys.
All right. We have a jail case, Larry Corgan. We'll skip over that. 2026 CR 19870, State versus John D. Cottrell.
My case, Your Honor.
All right.
Wade Roman of Montgomery County Bar. I believe this is set for an arraignment today.
It is.
And I've passed up a waiver to Your Honor's clerk, waiving my client's appearance. We would plead not guilty. I don't think I've received a copy of the indictment.
Here is a copy of the indictment. I'll hand it to you.
Receipt of the copy of the indictment for case number 2026-CR-19870. We would plead not guilty to all counts therein, waive formal reading. We would ask this court for a status date, please.
Your Honor, please set this. I've spoken with him earlier. Please set this for status for Judge Wallace in August.
August the 11th for status.
Yes, sir.
Yes, Your Honor. Thank you.
2023 CR 19522, State versus Dawson, Tanner Colbert.
Judge, I represent Mr. Colbert. He's here on a review. He had a probation violation. He was to do an MRT class. It's my understanding that's a 12 or 13 week class. He's got a few under his belt. We kind of just need to keep monitoring it. He is doing those though. Maybe it's late September, just monitor, check. Well, you said you had 10 left?
11, minimum 11 weeks left.
Yeah. So September, just kind of keep a pulse on it.
September VOP day. September 29th.
Let that slide.
2022 CR 19241, State versus Janet Doyle Givens. Excuse me.
Good morning, Judge. I represent Miss Givens. We've got a motion to hopefully have her released from supervised probation and put on unsupervised probation. And hopefully she can participate here. I know she's logged on.
Well, I have admitted her to the hearing. She'll need to turn her camera on.
I'm trying to text her right now to get her on here.
Ms. Givens, if you can hear me, we need you to turn your camera on, please. Does the state
Can
have? Can't see
you
you.
hear me?
We can hear you, but I can't see you.
Do I touch the picture of where it's got my name?
There should be a
One
little.
second.
You're asking the wrong
See if
person.
that got it.
Instructions on how to turn your camera on. I don't. If you have
The
a
actual
coming in
camera?
on-
There should be some type of a video button, Miss Givens, on your Zoom app.
We got it. Wait a minute, I think I've got it. Can you see me? There you go. Can you see me?
I can see you. I can see you.
Okay.
All right. Does the state have any position on this motion?
No, I've spoken
Sir?
with Mr. Lockhart. I've spoken with Mr. Lockhart, and everything he states in his motion is true. It seems like wherever she's being supervised recommends this. I take no position.
Mr. Lockhart, if you'll draw an order, I will sign the order.
Thank you, Judge.
Thank you. Ms. Givens, thank you for appearing. You're free to go now. Do we have inmates up here already? Or are they all coming in on Zoom? Well, they haven't come in on Zoom. 2024 CR 19552, State versus John Anthony Hodge. Mr. Hodge, I showed that you were represented by Greg King. Is that correct?
Yes, sir.
Why is he not here?
He is in Davidson County. He sent me a text earlier saying, let's see what it says here.
He did converse with me yesterday. I don't remember him saying where his whereabouts would be.
He said he's got an emergency motion information called in on by Judge Bell. He said he's hopefully will get here as quick as he can, but he had to go into Davidson County first thing.
Have a seat. We'll see if he shows up. (2025) CR 19818, State versus Cassandra L. McGuire.
Judge, that's my motion. I filed a motion to withdraw. At this point in time, I think that
Yes.
the attorney-client relationship has reached a point of unrecognizable. I think ethically, I should withdraw from this case.
The state doesn't really have I guess we need to have a position. The only thing I would say is she filed a lengthy response to the motion to withdraw, referencing making $26 an hour. So I'm not sure Ms. McGuire is actually indigent. I know in general session she retained counsel, had a similar breakdown in communication, and represented herself at the preliminary hearing pro se.
All right. Are you Ms. McGuire? Ms. McGuire, come up. Ms. McGuire, you're a lawyer that you had appointed public defender's office. Mr. Bond has indicated as an officer of the court, based on the code of professional responsibility, that he can no longer represent you. So I am familiar with the rules of evidence or rules of procedure and what are the rules of professional conduct for lawyers. And as a result of that, I agree that based on his explanation that he can no longer adequately represent you ethically. So I'm going to allow the public defender's office to be withdrawn as your attorney of record. You have filed this lengthy motion, and in that motion you set forth that you obtained employment making $26 per hour. Is that correct?
Yes, sir. I started on June 8th.
Okay. Well, this court would find that that is equivalent to $4,000 some odd dollars a month, which under the rules and under the law would not make you indigent. And as a result of that, you would not be qualified to have appointed counsel at this stage. So I will give you an opportunity to hire an attorney, and then you can determine whether or not that you've been able to. But what I'm going to do is set you another status day to come back in front of Judge Wallace on September the 29th to let Judge Wallace know whether or not you've been able to hire an attorney.
Okay.
So
September would.
Oh, I'm sorry. When is the separate trial? Is it?
I believe it is in late September.
September.
All right, we'll set it in August then. August.
Yeah, I can tell you now I cannot come up with that type of money by August. That's unrealistic. I just started my job. I do have medical. That's actually a priority in my life, is medical, child support, living expenses, things of that nature. So August probably would not be enough time to hire an attorney.
Well, I'm still going to have you appear on August the 11th, and let us determine. Well, let's see, that's only a couple of weeks away. So what about the VOP day? We're going to have you come back on August the 25th and at least let the judge know what efforts you've made to try to obtain counsel. I understand your situation, but there is also a rule that says I cannot just appoint someone an attorney because they have bills to pay, but they make a good income. So it requires a showing of indigency. And right now, according to the evidence, I don't find that you're indigent. But you come back on August the 25th and Judge Wallace will take a look at it and see whether or not.
Considered it is a new job, and all the last minutes, I wasn't even properly served this motion. He rants all the time, pretty belligerent. I have not had a copy of that motion that he submitted. I'd like to have a copy of that. Also, can I do a Zoom hearing since it is a new job? So this disruptive pattern does not
Judge
cost
Wallace
me.
Zoom. Check with the clerk's office and they'll set up later on, and we'll see if whether or not you can set a Zoom. You're set for trial in front of Judge Lockhart Nash, and I cannot continue that trial date. She might very well be able to continue it to give you an additional time to hire a lawyer. But right now, all I'm doing is doing what I'm required to do, which is to allow the public defender to withdraw, and then we will give you another date to come back in. Hopefully you can do that by Zoom, but you need to follow up with the clerk's office after they're able to check with Judge Wallace's office to see whether or not you can come in on Zoom.
Okay, so yeah, they're the ones that told me to ask. He didn't want to do his job. So I'll check with the clerk's office to see if
I'm familiar with Mr. Vaughn, and you and I have different opinions about Mr.
That
Vaughn's
is correct.
abilities, but I think he's a fine lawyer and he does a good job. Sometimes people just get cross. So
Right.
you can be
I
back here
understand.
in
He
August.
he is not wanting. He's made his mind up. He's judge, jury, and everybody. I understand that he's all in one. However, I have a right to a defense counsel. I
We're
have a
trying to
right to
get your
defend
jury trial.
myself.
You have the right to a defense
Yes,
counsel
sir.
of your choosing. So
Thank
you
you.
go out and hire your lawyer, and you can hire that lawyer
I
as
will-
you have done in the past.
I will do that the best I can.
All right.
Thank you.
2025 CR 19721 State versus Sarah Meek.
Judge, this is actually Mr. Richter's case. I believe it's a motion to revoke bond. If we can just move that to August 11th.
That's
August
correct. Yes, sir. I spoke to Mr. Richter. He would ask to put it on one of his months. In this case, I agreed to it. So if we could reset it for August the 11th. we'll
August
ask
the
Mr.
11th.
Yes, sir.
2025 CR 19808 State versus Aaron Patrick Northcutt.
Your Honor, that would be Jake Lockhart. I believe he was starting in another county this morning with some motions and intended to come. So if you want a second, call that.
All right.
Where you
2021 CR 19135 State versus Jonathan Victory.
Sorry, this thing just keeps getting slammed.
How you doing, Your Honor?
That is yet to be determined.
All right.
Mr. Willoughby, have you reviewed this request?
I've not.
He completed the community corrections program in 2021. I'm sorry, in 2022, and was transferred to regular probation. He's filed a motion asking for early termination of his probation, which I'm not usually inclined to do, but I'm going to let the state look at your request and talk to your probation officer, and then I'll come back to you later in the day. Are you in charge of the swinging gate?
It's gravity.
It's always nice to see someone move up in their career. So.
Does this job tip?
All right. That concludes all of the people who are not in jail. Can we get the jail on the screen? Anyone in the courtroom who has a case that you understood you had to be here today that has not been called? Come up. What's your name?
Brian Nicholas.
That's another one I've got for expungement that I need to look into. So
Okay. Have a seat. I think the district attorney needs to review your case. All right. Can we get in touch with the jail, ask them to start bringing the inmates in, please?
I've got one inmate in in a holding cell right now.
I'm looking for something to do. So,
Got it, Judge.
all right, bring him out. Yes, I will.
Judge, this is Mr. Benjamin Richardson. This is going to be for plea. He's got 2 active cases. 198.
I'm sorry, what's the name?
Benjamin Richardson.
Good.
He's got 2 active cases, 19859 and 19858. He's going to plead to 19859 first. That'll be a violation of an order of protection, a misdemeanor. Sign right there. That's going to be 1129 to serve, credit for time served, and no contact with the victim. I assume lawful contact is okay for purposes of the child, General?
Whatever their custody agreement is, I would just say abide by whatever custody.
Abide by custody agreement.
We don't have one.
We'll have to get one. I'm just adding that, Judge, real quick. So that'll be 1129 to serve, Judge. He has a significant amount of time from 3/13 to today's date, and then he also has some pretrial time. If you'll recall, we had a bond revocation hearing, and I believe you were the sitting judge that revoked Mr. Richardson's bond. So there's more time. The other time I have to go find Officer Gizzy Bell isn't here today, who typically does the jail credits. And then as to 19858, he's going to plead to count 2 aggravated burglary, a C felony. That's going to be 3 years on TDOC, suspended to supervised probation. That's going to run consecutive to 19859, credit for time served, and don't go back to the residence. There was a weapon involved, and General Sylvia has requested that be forfeited. So effectively, Judge, it's a 4-year sentence. 1 to serve, 3 on paper.
All right, Mr. Richardson, raise your right hand. Let's place you on the road. Thank you. Step up to the microphone and state your full legal name.
Benjamin Parker Richardson.
Mr. Richardson, you're here today on 2 different cases, and you've heard your lawyer go over what you agreed to a disposition, but have you seen or been shown a copy of those charges and talked them over with your lawyer, and you and Mr. Vaughn discuss the range of punishment you're facing, as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of no contest. A plea of no contest means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be if this case went to trial. And that evidence will be used by me to find you guilty according to this agreement. Do you understand that?
Yes, Your Honor.
Do you understand, however, that you have the right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, Your Honor.
You understand you would have the right to have a lawyer and to have one appointed if you could not afford your own, which I've done with appointing the public defender.
Yes, Your Honor.
Do you understand at trial you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, Your Honor.
Do you understand that if you went to trial, you and Mr. Vaughn could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes, Your Honor.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, Your Honor.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I will do is to approve what your lawyer has worked out.
Yes, Your Honor.
Do you understand that's going to result in convictions, and those convictions are going to be on your record in the future to make more severe the punishment that you'll receive if you're ever again convicted of a crime?
Yes, Your Honor.
Do you understand everything I've explained to you?
Yes, Your
Do
Honor.
you want to plead no contest according to this agreement and waive your right to a trial?
Yes, Your Honor.
Is your decision to plead no contest today voluntary?
Voluntary. Yes, Your Honor.
Anybody forcing you to do this against your will?
No, Your Honor.
You understand that I cannot accept your plea unless I'm satisfied that you are guilty of these charges and there are facts to support it.
Yes, Your Honor.
Then I want you to listen as the general tells me what their evidence would be if this case went to trial.
Your Honor, on case 19859, which is the violation of the no contact order, on that that case in particular, Mr. Richardson was released from jail on August 8th. Cheatham County Sheriff's Department made contact with Miss Jessica Elver on August 26th. After Mr. Richardson had been released from jail, there had been many phone calls and texts, and he had showed up at her home twice following being released from jail on August 8th.
Okay.
And then as far as the aggravated burglary charge, that is the case ending in 19858. Mr. Richardson on August 7th was found in the home of Jessica Elver, and he was intoxicated at that time. He had come into the residence without any permission and was intoxicated sitting on her couch when she woke up that morning. When officers did respond, their vehicle was there for Mr. Richardson. Ms. Elver was able to provide officers with ring camera footage showing Mr. Richardson driving up to the home. In the vehicle, there were Jack Daniels bottle as well as can of beer as well in there. That would be the basis for the DUI plea, Your Honor.
The aggravated burglary plea.
I was going to say there's no DUI plea in this. It's a aggravated burglary is what we've announced. Count 2, 19858 is count 2. It's aggravated burglary.
There was supposed to be a DUI second, implied consent.
Okay. Judge, can you give me 1 second on that?
Sure.
May I have the plea sheet to make a change?
All right, at the jail, we have some females, and if you're ready to take one of them up, we'll skip over come back to Mr. Richardson in a minute. So.
Yes, Your Honor.
All right, bring in anybody you got.
Oh, I just sent them a check for you. Your Honor, this is Angel Williams on page 6.
All right. Ms. Williams, your attorney that you hired is Sonny Stevens, and she has asked that your case be moved to the next criminal docket call, which would be August the 11th. So we are moving your case to that day to allow Ms. Stevens to work on your case. So
Yes,
you will
sir.
be back here on August the 11th.
Yes, sir.
All right, thank you.
That's all the females I have, Your Honor.
All right, thank you. At the male jail, we're ready to take you up next. Is that a legal term, male jail?
Your Honor, this is Joshua Widener, page 5, docket number 18322.
Judge, I represent Mr. Widener. He's here on a VOP and has been in for a good while. I've spoken to General Willoughby, and he is going to admit that he's in violation and be reinstated to community corrections.
Reinstate to community corrections.
Correct, sir.
All right, and you're okay with doing this by Zoom? Mr. Widener, can you hear everything that we're saying?
Yes, sir.
All right, your lawyers indicated that you are charged with a violation of probation or violation of community corrections, and that he has worked out a deal where you're going to be admitting your violation of community corrections probation, but being reinstated on time served because you've been in jail for a while. Do you understand that to be the case?
Yes, sir.
All right. Raise your right hand then and let me place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your full legal, you can put your hand down now. State your full legal name for the record.
Joshua Adam Widener.
Mr. Widener, you're here on a probation violation, actually a violation of community corrections, but have you seen or been shown a copy of those charges so that you understand what you're charged with?
Yes, sir.
Do you understand that you have the right to plead not guilty to those charges and have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
Do you understand you would have the right to have a lawyer and have one appointed, which I've done by appointing the public defender?
Yes, sir.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty to this charge, you're waiving your right to that hearing and to the appeal? All I'm going to do is approve what your lawyer in the state have agreed upon.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to enter a plea of guilty according to this agreement?
Yes, sir.
Then upon your plea of guilty, I order that you be revoked to serve the sentence, but based on time served and with the agreement of the state and your lawyer, you will be reinstated on time served to community corrections. So when you're released, you'll need to make sure you stay in touch with your community corrections officer.
Yes, sir.
All right, thank you.
Thank you. Your Honor, I have Matthew Hunt, page 2 and 3, docket number 19900.
What was the name, Judge?
For arraignment.
Okay.
Mr. Hunt, you are here today to be arraigned on an indictment charging you with aggravated assault, false imprisonment, and reckless endangerment. You have the right to an attorney. Do you wish to have a lawyer represent you?
I am in private law enforcement. I have access to U.S. Law Shield, which has been blocked by this county's jail. So I have not had access to the outside world since I was grabbed here without any notice whatsoever.
Well, I understand that may be your position. My question to you is, do you wish to have a lawyer appointed to help you with your defense?
Like I said, I do have them pre-retained, so yes.
You have someone retained?
Yes, U.S. Law Shield. It's an insurance for law enforcement, and this county has been preventing access. The numbers are blocked here, so I've not been able to call out since I've arrived.
Well, here's what we're going to do. I'm going to appoint the public defender, who is our local counsel for indigent clients or people who are incarcerated. They will be appointed to represent you, and they will help you if you need to get in touch with the U.S. Law Shield and get around whatever the problems are. So I'm going to appoint the public defender, Mr. Vaughn.
Just to complicate matters further, Judge, we will have a conflict in this. There was an individual involved that we represent and actively do. Stalker.
All right.
Are you familiar with this case, or are you just mass processing?
Am I what?
Familiar with this case, or are you mass processing everybody? Are you external to this case?
I have not reviewed your file. No, I am aware of the charges that you have against you, and today's purpose is to try to arraign you on the charge and get you a lawyer. So I have not reviewed your file.
Okay, because they're false charges, demonstrable by significant evidence, and it begs the question of whether or not the evidence was ever submitted by the officers. Because I was the one that was detained. I was the one under assault and battery from this convicted felon that had kidnapped this 5-year-old.
I can assure Mr. Hunt that all the evidence was presented to grand jury, and this is the result.
All right, the district attorney tells me that the grand jury has reviewed all of the evidence in the case and that they are the ones who returned an indictment. So I would suggest that we need to get you with a lawyer as quickly as possible, let you get in touch with this U.S. Law Shield, and then you can go from there regarding your defense.
Okay, so they reviewed the 3-minute surveillance from my truck 5 feet away.
I was not in the grand jury, sir, and I cannot tell you what the grand jury did because the grand jury process is, if you're in law enforcement, then you should know the grand jury process is confidential and secret, and they are the only ones who make a determination of what the evidence is.
I'm third party.
I'm going to appoint Mr. Olin Baker of Dickson County Bar to represent you, and Mr. Baker will be notified of that, and you can contact him. His number shouldn't be blocked by the jail, but he is in Charlotte, Tennessee. Let me see the indictment. In order to arraign him, I'm going to read this indictment to you so that you fully understand what the grand jury has done in the case. So this is in the Circuit Court for Cheatham County, Tennessee at Ashland City, July term, grand jury 2026. The grand jurors of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about May 9th, 2026, in Cheatham County, Tennessee, and prior to the finding of this direct presentment, Matthew J. Hunt then and there did unlawfully and intentionally or knowingly cause Jason Olav Lynn to reasonably fear imminent bodily injury while utilizing a deadly weapon, to wit, a gun, and holding Jason Olav Lynn at gunpoint, which is in violation of Tennessee Code Annotated 3913-102, a Class C felony, all of which is against the peace and dignity of the state of Tennessee. Count 2, the grand jurors of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about May 9th, 2026, in Cheatham County, Tennessee, and prior to the finding of this direct presentment, the said Matthew J. Hunt then and there did recklessly engage in conduct which placed or could have placed another person or persons in imminent danger of death or serious bodily injury by use of a deadly weapon, to wit, a firearm, in violation of Tennessee Code Annotated 3913-103, a Class E felony, all of which is against the peace and dignity of the state of Tennessee. Count 3, the grand jurors of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about May 9th, 2026, in Cheatham County, Tennessee, and prior to the finding of this direct presentment, the said Matthew J. Hunt then and there did knowingly and unlawfully remove or confine Jason Olav Lynn to interfere substantially with Jason Olav Lynn's liberty by holding Jason Olav Lynn at gunpoint in violation of TCA 3913-302, a Class A misdemeanor, all of which is against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General for the 23rd Judicial District, and it was endorsed by all of the members of the grand jury. And therefore, I will find that he has been arraigned. Mr. Baker has been appointed to represent him. The status date for Mr. Hunt, please. General, status date for Mr. Hunt.
Yes, it's my status date, Your Honor.
Co-defendant was probably said November 10th.
That's what I'm gonna double check on. I do believe they were set November 10th, and that would be with Miss Sapphire Lenentine.
Lentine.
What's that?
You said November the 10th for
Yes,
status.
yes, Your Honor.
Okay. All right. Case is reset for status for November the 10th. Mr. Baker will be in touch with you as soon as he's notified so that you and he can discuss your ability to go ahead and get in touch with this U.S. Law Shield as well as any bond issues. Mr. Baker will be the one that'll help you with those things.
Yeah, that was the other issue. There's no need for bond. I would have been here with a simple phone call or a summons. I was never informed this was being followed up on. I tried following up with the officers on the case and no response.
Well, I've told you what the grand jury of this county has found in the probable cause they've found, and I've now given you a lawyer. So you may consult with your lawyers as soon as he's in touch with you and take the steps that you think would be appropriate. That will conclude your portion of this hearing. Thank you.
That doesn't include any bond information. When does that happen?
Give me Turcotte. Turcotte. McManamy. Absolutely. Your Honor, I have Isaiah McManamy, page 3, docket number 19168.
Judge, I represent Mr. McManamy. It's going to be for disposition today. He's also here on a violation of probation, Judge. He's going to admit that he was in violation and be reinstated to probation.
All right. Mr. McManamy, is that correct? How to pronounce your name?
Yes, McManamy.
All right. Will you raise your right hand and let's place you under oath? You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
I swear it's the truth.
All right. Thank you. You can put your hand down now. State your full name for the record.
Isaiah John McManamy.
Mr. McManamy, you are here today on a probation violation. Your lawyer indicates that you want to enter a plea of guilty to that charge and be reinstated to probation on time served. But do you understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, Judge.
Do you understand that if you had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with the public defender?
Yes, Judge.
You understand that if we had the hearing and I found you guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of guilty, you're waiving your right to that hearing, to that appeal? All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to that hearing?
Yes, sir.
And upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but based on the agreement with the state and on time served, you will be reinstated to probation.
And Judge, might I add too, I forgot to make this announcement. Roderick reminded me that this also, it will be required with his reinstatement that he find some sort of treatment program and complete that as well.
Part of this agreement is to reinstate you to probation. They want you to, it's not going to be they want, but you're going to be required to enter into some sort of a treatment program. Do you understand that?
Yes. Something longer than 30 days.
Something longer than 30 days. And if you don't do that, that just means you'll be right back here in jail again. Do you understand that?
Yes, sir.
All right. Good luck with you. I hope you can get some treatment.
Thank you.
Thank you.
This is Patrick Peters, page 4, docket number 19294.
Judge, I represent Patrick Peters. He's here for a violation of probation. I've spoken to General Willoughby. He as well is going to admit he's in violation and be reinstated.
Mr. Peters, raise your right hand. Let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. Put your hand down. State your full name for the record.
Patrick Lee Peters.
Mr. Peters, you're here on a probation violation. You need to understand that you have the right to plead not guilty to this charge and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation. Do you understand that?
Yes, sir.
Do you understand that you would have the right to have a lawyer and have one appointed if you could not afford your own, which we've done with the public defender being appointed?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of guilty, you're waiving your right to that hearing, to the appeal? All I'm going to do is approve what your lawyers worked out with the state.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to that hearing and to the appeal by pleading guilty?
Can you say that one more time, please?
Sure. Do you want to take advantage of this plea agreement to get out of jail?
Yes, sir.
Then upon your plea of guilty, I find you guilty of violating your probation in order that you be revoked to serve your sentence, but I'm going to then reinstate you to probation on time served by the agreement of the state and your lawyer. So they're going to release you from jail. Are there any conditions on this case?
No, Your Honor.
Mr. Peters, how old are you?
22, sir.
All right, 22. I vaguely remember being 22. Stay out of trouble so we don't have you back in jail again, okay?
Sir.
All right, good luck.
Thank you. Sorry.
Your Honor, I have Nathan Warren, page 5 and 6, docket number 18775.
Judge, I represent Mr. Warren. This is actually Mr. Richter's case. I believe he is trying to find some sort of treatment facility. If we could put this on the August VOP date. That's right.
August 20.
I suppose when Synergy. They have a bed open. I'm sorry.
We're going to reset your case to allow your lawyer to try to find you a treatment program. We're going to reset it for next month, August 25th, to let Mr. Richter go ahead and try to get something done on your case. Okay.
Yes, sir. He told me that I had a Synergy bed open.
Well, that might be true, but he's not here today, so I'm just filling in for his stuff. So he can get you in August, but
Thank you.
all right.
Your Honor, I have Larry Corbin, page 1, docket number 19256.
All right. This is for arraignment. Mr. Corbin, you're here on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
All right. I'm going to appoint the public defender to represent you. They're here in the courtroom. I've handed them a copy of the affidavit of violation of probation. Mr. Vaughn, you wish a formal reading of that?
I do not. I will waive that, Judge, enter plea of not guilty. I would like to know when these cases are set in Metro.
Do you know when your Metro cases are set?
They're still open. They don't have no court date or nothing.
I would suggest, let's see, October VOP day.
All right, we're going to reset you for October the 20th to allow your public defender to try to see what happens in your other cases.
And any chance of a bond?
Well, you can talk to Mr. Bond when he comes to talk to you about whether or not you can file a motion for a bond. A bond is not automatic in a violation of probation case, and that's the reason there was a hold for hearing in your case. So Mr. Bond can talk with you about the advantages or disadvantages of trying to seek a bond.
Okay.
All right, thank you. They'll be up to talk to you.
All right.
Your Honor, I have Gary Henson, page 2, docket number 19564.
Mr. Henson, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, I'll appoint the public defender to represent you. Handing them a copy of the affidavit of violation of probation.
We'll enter plea of not guilty on this, Judge.
Plea of not guilty is entered.
Same question as before.
You have charges pending in another jurisdiction, is that correct?
No, the case was dismissed, Your Honor.
I'm sorry.
Case was dismissed in Robertson County.
All right.
Robertson County was dismissed.
If we can put that on August VOP date.
All right, August the 25th. We're going to reset you for the VOP day next month so that your lawyer can get verification of those charges being dismissed and be ready for a hearing.
Yes, sir.
Thank you.
Thank you.
Palmer. Your Honor, I have Antoine Palmer, page 4, docket number 19579.
Judge, I represent Mr. Antoine Palmer. He's here on a violation of probation. I've spoken to General Willoughby. Mr. Palmer is going to admit these in violation, be reinstated. He will also need to do an alcohol and drug assessment and follow any recommendations following that.
All right, Mr. Palmer, raise your right hand. Let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. You can put your hand down now. State your full name for the record.
Antoine Maurice Palmer.
Mr. Palmer, you're here today on a probation violation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed, and we've done that by appointing the public defender for you.
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving your right to that hearing, to that appeal. All I'm going to do is approve what your lawyers worked out with the state, which is going to be to reinstate you to probation after I find you guilty.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to that agreement?
Yes, sir.
And upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but on time served and by agreement with the state, you'll be reinstated to probation with the additional condition that you must undergo an alcohol and drug assessment and follow any treatment recommendations. In other words, that's going to be on you to get that done with your with your probation officer giving you directions on how to go about doing it. You understand
Yes,
that?
sir. Yes, sir.
What will happen if you don't follow that treatment recommendations or don't do that A&D assessment?
Yes, sir.
What will happen?
Probation violation.
All right. Be right back where you are.
All right.
Okay. Well, good luck to you. I hope you can get that worked out.
All right. Thank you so much.
Your Honor, I have Paul Johnson, page 3, docket number 19612.
Judge, I represent Mr. Well, he is here on a probation violation. This is kind of an odd one, Judge. He was set to be his probation to terminate in May in front of Judge Lockhart Mash. He was late to court, and she put out a capias on him. He then was, while the capias was out, he caught a new charge, which he is now on probation in Sessions for. So being that he was going to be terminated anyway, was just late, we're just terminating his probation here, and he can just worry about General Sessions probation.
So with all of that explanation, basically what you're telling me is that this probation violation is going to be dismissed.
Yes.
Okay, is that correct? Yeah. All right. We will dismiss the probation violation. Thank you.
Thank you, sir.
Dickson. Your Honor, I have Elijah Mixon, page 4, docket number 19659.
Judge, he is mine as well. He's here on the violation of probation and stemming from new charges. Those charges were dismissed, so he is going to be reinstated to admit he was in violation.
So he's going to admit his violation, be reinstated?
That's correct, Judge.
Mr. Mixon, raise your right hand. Let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. Put your hand down now. State your full legal name for the record.
Elijah Sean Mixon, Sr.
Mr. Senior, is that correct?
Yes.
Mr. Mixon, you are here today charged with probation violation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty to this charge and to have a hearing in this court to determine whether or not you had violated your probation? The state would be required to prove to the legal standard that you had violated your probation. Do you understand that?
I do.
Do you understand you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
I do.
Do you understand that if you had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by pleading guilty, you're waiving your right to that hearing and to that appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes.
Do you understand that that means you're going to be reinstated to probation because those underlying charges were dismissed, so you're going to be back on probation? Do you understand that?
Yes.
Do you wish to plead guilty according to that agreement and waive your right to that hearing?
Yes.
That upon your plea of guilty, I find you guilty of violating your probation, order that you be revoked to serve your sentence, but by agreement of the state and on time served, you will be reinstated to probation Any additional conditions? Go
No,
ahead.
Your Honor.
You'll need to see your probation officer when you're released from jail, okay?
Okay.
Thank you.
Thank you.
Hillard? Actually, Your Honor, this is Donovan Hilliard, page 2, docket number 19707.
All right. Mr. Flanagan represents you, Mr. Hillard, is that correct?
Yes, sir.
Have we heard from Mr. Flanagan today?
No, sir. I don't. This was one I just asked to put on the docket because I had done a superseding indictment adding a count. It's set for trial, I believe, in September. So if we could leave it set for trial and just formally have him served with his new count on his new indictment.
All right, there's a superseding indictment. One of my former clients referred to it as a supersized indictment. Superseding indictment means that they've gone back to the grand jury to correct something or add something to the indictment against you. So Mr. Flanagan is your attorney. And Mr. Vaughn, standing in for Mr. Flanagan on behalf of Mr. Hillard, do you have any problem with waiving the formal reading of that count 2 of that indictment?
We'll waive that, Judge, as a plea of not guilty.
Since you don't represent him, Mr. Flanagan does, I think maybe I'll read that count 2 just to be sure he's arraigned properly. So,
okay.
The superseding presentment that we've had, the count 2 that was added, I want to read that to you so that you've been arraigned on that. The grand juries of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about July 27, 2024 in Cheatham County, Tennessee, prior to the finding of this presentment, Donovan W. Hillard then and there did unlawfully and knowingly deliver a substance containing fentanyl, a Schedule II drug, or any analog or derivative thereof, and the violation resulted in the death of another person, to wit, Tyler B. Craig, caused by fentanyl or any analog or derivative thereof, either alone or in combination with any substance scheduled as a controlled substance, including controlled substance analogs in violation of TCA 3917, 417K2, a Class A felony, which is against the peace and dignity of the state of Tennessee. Signed, W.A. Crouch, Jr., Assistant District Attorney General. All right, we'll show that the plea of not guilty to the superseding indictment, superseding presentment, rather, has been entered, and a copy of that will be given to Mr. Flanagan. We'll go from there. Thank you. It remains set for trial in September.
Your Honor, I have Jeremy Greenwood, page 2, docket number 19797.
You are represented by Jake Lockhart, is that correct?
Yes, sir.
Mr. Lockhart has apparently chosen to go to another court before he came here, and we will. Are you stepping up for Mr. Jake Lockhart, Mr.
I'm
Eric
trying
Lockhart?
to get here, Your Honor. Yes, sir, I am. Mr. Lockhart asked me to step in for him today. He's in Waverly and doesn't know when he's going to get back. There's a plea worked out, I believe, in regards to that. I'm willing to announce that, and if the court will take that as well.
All right. You want to announce the plea?
The plea that I'm understanding is the defendant has the following criminal history, but he will. Okay. If it pleases the court, Your Honor, Mr. Lockhart just handed me this. He got his name on it. So I'm just trying to figure out exactly what they've done here.
My email I sent you.
Okay.
It's going to be a plea to count 1 of possession, Schedule 1 for resale, Class B felony, 8 years on state probation as a range 1 offender, dismissing counts 2 through 4 with mandatory minimum fines and costs.
So are we going to do this in person, or are you going to have him do it by Zoom?
I have it brought up so we can fill the paperwork.
All right. We'll need to bring him up.
That'll be fine.
Are you comfortable, not competent, but are you comfortable with helping him to enter this plea?
Yes, sir. I understand that he's had this conversation with Mr. Lockhart. I believe that is correct. He's waiting. He said,
All right,
yes.
Mr. Greenwood, we're going to bring you into the courtroom here in a few minutes to go ahead and finalize this plea agreement. You'll have to sign off on the plea sheet to make sure that you fully understand what you're pleading to. So we'll bring you up. Okay.
Okay, thank you, sir.
Your Honor, I have Moore Mayo, page 3, docket number 19423 and 19424.
Has anyone heard from Mr. Joseph Fuson?
I have not, Judge.
Okay. Mr. Mayo, your lawyer is apparently had to go to another court first, so we're going to have to put you on the second call. He'll be here as soon as he can.
Okay.
All right. Thank you.
Your Honor, I have Ricky Palmer, page 4, docket number 19738.
Mr. Eric Locker.
Your Honor, I've discussed this matter with the DA here, Mr. Willoughby, in regards to that. We've come to the agreement if we can place him on another month. I believe he has not gone to the grand jury yet, or is in the process of the new charges, which is the subject of this.
So you want to move him to August?
I would do September. That'll be the next grand jury.
September 29th. All right. September 29th, Mr. Palmer, your lawyer is working on your case.
Yes, sir. Thank you.
Thank you, Judge.
All right.
Your Honor, I have Michael Turcott, page 5, docket number 19157.
Good morning.
I represent Mr. Turcott, Judge. After having our violation of probation meeting with General Willoughby and the probation officers, if we can reset Mr. Turcott to August VOP date, we're going to try to get him into our mental health court program here.
Your Honor, I already have one of those set up for when I get out.
Well,
my fiance set it up already.
Set up what?
A mental health program that I can start when I leave here.
Well, that's a little different. We have a new mental health court that's a similar situation to the recovery court that we have already in place. Judge Turnbow is the presiding judge over that. It's my understanding that it's not as simple as saying that you're going to go into a mental health program. The state is requiring or is advocating, if I understand correctly, that it be.
This is actually a case that General.
Who can't hear you unless you're at the microphone.
The General Sagi's been working on with, I guess, Mr. Richter. So, but she is opposed to any mental health treatment. But she asked that for me to say that and to have it put in August.
All right.
Your Honor, is there any way I could reinstate today and go do my own mental health when I get out of here?
You just heard the state say that the district attorney who's handling your probation violation is opposed and opposes that you just be released on a violation of probation and be reinstated to probation to handle your own mental health situation. Your lawyer, Mr. Vaughn, is working, or Mr. Richter, I think, is the one who's representing you, is working to try to get you into a mental health program that would involve you being released and going in through a mental health court that we have. But it is not something that they're going to be able to do today. Now, the other option is we simply have a violation of probation hearing if he's not satisfied with what you're suggesting, and I'll make the determination whether to revoke him and send him to prison or to give him this other opportunity. It doesn't matter to me.
We'd advocate for the other opportunity, especially if General Sagi is involved in this, then I don't want to dispose of it if she's not here.
Well, Mr. Richter, your lawyer is not able to be here today. And as a result of that, I'm going to reset it for August the 25th. Mr. Richter will be in touch with you before that date, and you can explain to him what you're advocating. And then the judge who's here on August 25th will make a decision whether or not that will be acceptable or whether or not there'll be something else. So,
excuse me, Your Honor. I don't mean to interrupt. The mental health thing, when do I go for that? When do I come up for that?
The mental health court is what they're saying. They were trying to arrange to get you into it, and that would be in August when you come back to court.
Between now and his court date.
Yes, can I do that? I'm having hot problems hearing you through here.
You're having what?
I was having difficulties understanding everything that was being said earlier through this computer. Is there, can I go through the mental court thing?
That's what they're trying to approve. The
Okay.
district attorney's office is opposed to you getting mental health treatment. They want to send you to prison. Your lawyer's working feverishly to try to get you into this mental health court so that you can get some help instead of just being incarcerated.
Yes.
And what we're doing is we're going to put it on next month's docket to give the judge an opportunity to hear from both sides about whether or not it's in the state's best interest, public's best interest, and your best interest to get you into this mental health court. If it is approved, the mental health court would get you into treatment and then have a follow-up through that court system, similar to what somebody does who goes into a drug court or recovery court. But it's all your lawyer's trying to help you to avoid just simply going to prison. Do you understand that?
Yes, Your Honor.
Okay. Give them a chance to work on your case, and then hopefully I think you'll be happy with the results. But we're going to put you for next month to give you an opportunity to have that heard before a judge. Okay.
Okay.
All right.
Thank you, Your
August
Honor.
25th.
August 25th.
August 25th.
Your Honor, everybody else you wanted was on a second call.
All right. Are we ready on any of the other things for second call?
I just need an opportunity to.
All right. Well, let's go ahead and take a recess for the morning. So you've got the A team that's shown up, Mr. Hodley.
Yes, Your Honor. Did you hear the music?
Yeah.
Why are you sitting with the interview?
I told him, I think it's the same one that had communicated with Jennifer, and she sent it to me, and I tried to send him a text to say be here at 10:30. So yes, tell him to come back. All right, we'll stand in recess. How long do you need, Mr. Vaughn?
Well, Mr. Chambliss has shown up. I need to go over the DUI plea with him.
More than 15 minutes?
If you could give me 20, that'd be perfect.
20 minutes.
All right.
All right, Mr. Ball, we had, I think, taken a recess to assist you. So
Yes.
How about it?
Okay. Well, first and foremost, I've got Mr. Charles Chambliss. He did come in. I've spoken to him briefly. As I said, I have not had time to discuss his discovery with him. If we can just get a November status date.
November the 10th.
Get your card. There you go, Mr. James. Yep. Then I have Mr. Richardson that's still over there. That's ready for plea too, Judge, if you want to do that.
All right, let's do that next. You remember where I got to?
Yes, we went through all of the rights.
It was a kind of a semi questioning you to see if you were paying attention to where I got to.
Sometimes I am, Judge, I promise.
All right, do we have the new plea sheet?
Well, we have a modified version of the old one. So I'll just kind of start from the beginning. 19859 is a violation of order of protection, a misdemeanor. That's going to be 1129 to serve. He's got credit from 31326 to 72826 and 82725 to 121825. Credit for time served. No contact with the victim in this matter. It needs to be done through attorneys until there's some sort of custodial visitation schedule established. District Attorney Sylvie also wanted to ensure that the names of the victim's children are on there to not be no contact with them. They are not. Mr. Richardson's. And then running consecutive to that is 19858. Aggravated burglary. That'll be 3 years of TDOC, suspended supervised probation, consecutive, as I said, to 19859. Credit for time served. Don't go back to the residence. Then what was added was the DUI second, a misdemeanor. The standard minimums for that 1129 after 45 days, concurrent with 19858. Loss of driver's license for a year. Ignition interlock device, $600 fine. I think that's it. All of the counts are dismissed. Oh, I've gone over the DUI enhancement form. He understands that effectively the more you get, the worse you get. We've gone over those in detail, Judge. And his signature is already on it. Well, sign right here. It's the enhancement form.
All right. Mr. Richardson, we had previously placed you under oath, and I'm just going to kind of briefly go back over what we've talked about. You understand that you have a right to plead not guilty and to have a speedy and public trial by jury, and that you would have the right to have a lawyer, have one appointed like we've done with the public defender. Do you understand that?
Yes, Your Honor.
You understand if you went to trial, you'd be presumed to be innocent until the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted. Do you understand that?
Yes, Your Honor.
You understand that if you went to trial, you and Mr. Bond could confront and cross-examine all witnesses that the state called. You could bring in your own witnesses of your own choosing by using a subpoena. You wouldn't have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand all of those things?
Yes, Your Honor.
You understood that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you.
Yes, Your
Honor. That. And you understand that by entering this plea, you're going to have convictions that will be on your record that in the future were to make more severe the punishment you'll receive if you're ever going to be convicted again.
Yes, Your Honor.
For example, as Mr. Vaughn has pointed out, you've handed me a document called a notice of DUI punishment. And it sets forth every enhancement that each of the convictions that you get for DUI carry the next time around a more severe punishment because of this. And you understand all of those?
Yes, Your Honor.
All right. Is that your signature on that document? Do you have any questions about the DUI enhancement?
No, Your Honor.
Do you understand that pleading no contest is voluntary on your part? Is that correct?
That is correct, Your Honor.
Nobody's forcing you to do this against your will.
No, Your Honor.
Then you understand I have to have facts supplied to me, and General Sylvie had started giving me those facts. And the facts regarding your DUI had to do with the fact that you were found in possession of Jack Daniels and what else was it? Jack Daniels and a beer. That sounds like a country music song, doesn't it? In any event, that's the basis for your DUI conviction. Do you understand that?
Yes, Your Honor.
You understand everything that's been, was there any other evidence that needed to be supplied?
No, Your Honor.
All right. Are you satisfied with your attorney's services?
Yes, Your Honor.
You feel like Mr. Bond's done a good job of representing you on all these charges?
Yes, Your Honor.
Mr. Bond, do you know of any reason he should not enter this plea?
No, Judge, I do not.
Anything else from the state?
No, Your Honor.
And Benjamin Richardson in docket number 195858 and 19859 will start with the violation of the order of protection. That's 19859. Upon your plea of guilty to that charge, a plea of no contest, I'm sorry, you're sentenced to 11 months and 29 days in the county jail to serve with credit for time served. You're ordered to have no contact with the victim in this case and abide by any custody arrangement. The minor children's names are added to this document as to having, and Mr. Bond, did I understand you to say he's not to have any contact with the children or only by a custodial arrangement?
So there are 4 children involved, Judge. The listed children are not his biological children. They are hers.
All right.
But only for his child may he, after a custodial agreement is established.
Right. Then the docket number 19858. On count 2, you're found guilty of aggravated burglary, sentenced to 3 years Tennessee Department of Corrections, suspended to supervised probation. But that will be consecutive to the prior 1129 you have to serve. Be given credit for time served. Do not go back to the residence, and the weapon will be forfeited. On the count involving driving under the influence of an intoxicant, that would be a Class A misdemeanor. You're sentenced to 11 months or 29 days in the county jail, suspended after 45 days. That will be concurrent with the prior case where you're serving 3 years on suspended probation. Loss of driver's license for 1 year. Ignition interlock will be required for you to get a license, and you get a $600 fine and cost. The dates of your incarceration are set forth on this document for you to get the pre-sentence jail credits. That's the judgment of the court. Thank you. All right. You have something, Mr. Willoughby?
Got a law school bar exam question.
I'm not sure I even want to hear it. So.
I'll fill you in. This is Mr. Nicholas, I believe. So he filed to get off of the sex offender registry, which was a condition that he could ask the court to do once he completed his term of probation. It appears from the file he has completed his term of probation. In conjunction with that, I think he's also filed to have that expunged off of his record. There's a form for him to apply for that, and then there is another piece of paper that's not attached that says it's ineligible, and it cites 4032-101 A1D, I think. But when I look up that statute in Westlaw, there is no A1D section. But then when I just put it into a Google search, it shows a 2024 statute, a version of that statute that does include the reasoning for not being eligible for expunction is because it's listed as a sexual offense. So I think that was a reason for denial at some point in time, and still may very well be, but they may have changed or moved what statute it is in reality.
So I don't have a good answer to whether he can have that expunged.
Well, the agreement he entered was judicial diversion for 2 years, which, if successful under that statute, seems to say that he would be automatically entitled to an expungement.
Well, there's an exception to those expungement of those charges, which is quoted in the document. I don't know what the title of the document is. I think it's just an eligibility certificate for expungement that cites, again, the 4032-101. But the citation is not current according to my Westlaw. So, but at some point in time, there appears to be an exception, which, in talking this out amongst everybody but you, I would assume that would mean he would not be convicted of it, but it would remain on his record, which makes, I guess, he would not be a convicted felon. But
Judicial diversion, by the case law that I'm aware of, is that a person's never actually convicted if the prosecution is deferred. So if a person has never been actually convicted of the offense, then it would certainly seem to me that under the law, whether I agree with it or not, then they would be entitled to have an expungement of a case that is dismissed because it was never convicted. So I don't see how it could be anything different. Because otherwise you're saying he can't have expunged the fact that he was never convicted of a crime.
That's what the TCA appeared to say at some point in time. But that code section, as I currently look it up, no longer either has that section or it's misquoted. But at some point in time, there was an exception that is in that sentence that says, even if you had a diversion, you can't expunge it, but I guess you're just not convicted.
Because the appellate courts have ruled consistently over the years that a judicial diversion means a person has never been actually convicted.
This is the first time I've heard of an exception to the expungement of a judicial diversion. Because even under a domestic assault conviction, you can't get it expunged, but you can get a diversion for it, which gets it off your record. So I don't have a good answer. That's what I've been doing for an hour or more to try to figure it out.
So the TBI's records or their eligibility for expunction contains the comments that you were referring to, where they make reference to the fact that he is not eligible for expungement.
But when I look up the 4032-101, it has no section A, lowercase a at all. But if I just did a Google search, it shows a different version that does have the A1D.
Well, the administrative officer of the course has given me the LexisNexis CD for supposedly the most current status of the law, and I'm going to refer to it rather than Google search. I understand. I've Google searched as well about things, but if this is a code section, it ought to be in the code. If it's not in the code, it doesn't apply. Excuse me. Well, clearly he would be eligible to come off the sex offender registry because of the fact that he has completed his probation, and that was part of the condition of the plea. So I'm going to grant his request to be removed from the sex offender registry. As far as the expunction goes, I don't think the statute that they have cited, 4032-101A 1D, does not exist as far as, and I know that's what you were saying. 4032-101 is the definition section of the destruction of records upon acquittal and so forth. There is nothing in that record that appears to me to apply that says where they quoted it. The exclusions, Mr. Willoughby, that I'm looking at under the 4035-313, there are exclusions and for individuals that are not eligible to have their record expunged, and those are set forth as sexual offenses definition, and it lists, for example, aggravated prostitution, aggravated rape, etc. And it goes on down the list. Nowhere is the statute under which Mr. Nicholas was convicted is mentioned in that exclusion of expunction.
No.
So I'm going to sign the order for the expunsion because, in my opinion, the current state of the law is that the Court of Criminal Appeals has held that a judicial diversion is not a conviction, and that anyone who is charged with a crime but never convicted, in my opinion, is entitled to have it expunged. There is nothing in the judicial diversion statute, nor do I find in the expunsion statute that would indicate he's not eligible. So we'll see what the TBI says. So.
And there's a TBI certificate stating the statute's eligible for diversion when he originally entered the plea.
I have ordered that he be removed from the sex offender registry, and also that he be that the record be expunged because that was part of the agreement at the time. So there needs to be an order done, but Ms. Stevens was his lawyer. I don't know if she was appointed or retained, but it seems to me.
Your lawyer? Or
No, I did not know.
He said that she was appointed.
If she was appointed, then I would suggest we could contact her to see if she will prepare an order on this. contact Ms. Stevens and tell her that she needs to do an order releasing you from the sex offender registry.
I hired her to 2023 right before I was convicted.
I'll email her. Don't
And to
worry.
the plea.
Gotcha.
Is there anything else I need to do before I leave here?
I would just leave as soon as possible.
So I just have to wait.
Okay.
Thanks.
Mr. Vaughn, you have anybody else ready?
Well, I have an announcement, Judge. On Timothy Baxter, I talked to him during the break. He had car trouble. That was supposed to be for plea. If we can move him to the 8th, I know that he wanted to be here because he was wearing the ankle monitor and has a keen interest in getting that off. So
You're talking about August the 8th?
it is the
August the 11th. Is that the date?
11th, right?
August the 11th?
If we can do that, Judge.
August 11th.
Perfect. Thank you so much. And I've got 3 more inmates left for, those are all 3 for hearing, and then that's all I've got.
All right. Mr. King, you had a case, I believe.
Yes, that's John Hodge. We're ready whenever you're.
John Anthony Hodge.
Yes, sir.
Hang on.
Mm-hmm. He's never breached it either. But I have few clients.
If this case is still under discussion, I'll go ahead and take up some other matters.
Oh.
Admit extended 6 months.
Yes.
Moving to page 3, 2023 CR 19423 State versus Roy D. Mayo.
Morning, Your Honor. Joey Keys on behalf of Mr. Mayo. That's the plea this morning. Got the paperwork drafted up, and I'll meet with Mr. Mayo, get him to sign everything.
Are you still working on the paperwork?
I've got the paperwork pretty much ready. I'll let Mr. Mayo's been brought up. So.
All right. Who do we have here?
We're going to have an announcement.
This can be announced. Mr. Mayo, I think it's going to be met with.
All right. So what are we doing?
Oh, Hodge, Your Honor, probation violation, page 2, bottom page 2.
He's going to admit his violation, extend his probation 6 months.
He also has a driving on revoked license.
We're still litigating that, Your Honor.
So all we're dealing with today is the probation violation?
Yes. And he does have a license and insurance and interlock.
All right. Mr. Hodge, if I understand correctly, he's going to be entering a plea of guilty to probation violation and have be found guilty and have his probation revoked, but then return to probation extended for 6 months. Is that correct?
Correct.
Mr. Hodge, raise your right hand. Let's place you under oath.
We'll do it. Okay.
That it?
State your full name for the record. State your full name for the record.
John Anthony Hodge.
Mr. Hodge, you're here today on a probation violation. Do you understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
Do you understand you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to a hearing and to an appeal? All I'm going to do is approve what your lawyer has worked out with the state. That's going to result in your probation being revoked, but then I will immediately return you to probation, but extend you for 6 months. Do you understand that?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
You want to plead guilty according to this agreement to waive your right to a hearing?
Yes, sir.
Then upon your plea of guilty, I find you guilty or that you be revoked to serve your sentence, that by agreement with the state, I will return you and reinstate you to probation in order that you be extended for 6 months. He needs to continue seeing his probation officer. Thank you. Excuse me. didn't yet, but let's go ahead and set it. Mr. Willoughby or Mr. Hodder, would one of y'all ask Mr. Hodder, Mr. King to step back in here, please?
Yes, Your Honor.
State's going to move to just nolly his 19843 case.
That answers my question. Did you get that, Madam Clerk?
Skip it.
Oh, you called me.
We thought we were going to have to set you a new date on this 19843 from Mr. Hodge, but the state preempted it by saying that they're nulling that case. So,
Okay. Thank you, Judge. Your Honor, I called in. I apologize. I had an emergency motion. I was usually get here by 9.
It's all right.
Did you give him Roger? Huh? Did you give him Roger? Okay.
Who do we have here?
This is Mr. Skipworth.
Mr. Who?
Skipworth. It's going to be LP hearing.
On page 5, Raymond Daniel Skipworth for hearing on the violation of probation. State ready?
Yes, Your Honor.
All right, state, you call your first witness.
Officer Davidson.
Step right up. Raise your right hand and be placed under oath.
Do you solemnly swear affirm testimony you give through the truth, the whole truth, and nothing but the truth?
I do. Officer, would you state and spell your name, please?
Roderick Davison, last name Davison.
And where are you currently employed?
State of Tennessee Department of Probation and Parole.
And are you in charge or were you in charge of trying to supervise Mr. Skipworth?
That's correct.
And when was he placed on probation with you?
11/1/23.
And did he show up initially or?
Yes, he did complete intake initially, and he was in the process of being transferred to the state of Kentucky.
And did that ever get done?
They denied it.
They denied him. Yes. After that, did he continue to report?
No, he was directed to report back to the state of Tennessee here.
And he never did that?
No.
So other than the initial intake in 23?
Yes.
Have you or anyone in your office seen him in person or anything?
Well, after he was picked up on the violation of probation, he was reinstated back on probation, on July the 30th, 24. So he did report, we did communicate, and he was again in the process of trying to be transferred back to Kentucky.
And this is in 24?
Yes, sir.
Was he denied again or
Well,
how did
yeah,
that go?
he left. Yes, I did 2 home visits and at his last known address, and I lost contact with him, and then I filed that second violation.
So this is the second time he's just kind of disappeared.
That's correct.
Any other issues? I mean, I guess you wouldn't know because you haven't been around him.
He was serving 1 year in Logan County, Kentucky, for FTA. And they just sent me the paperwork last week, but he's been a year up there. So when I was notified that he was up there, I had a hold placed on him so he could report back here.
So did he enter? So he entered a guilty plea of failure to appear there.
Yes.
So we're 2 states in with him just not showing up where he's supposed to be.
Yes.
Is there anything else the court needs to know about his supervision?
That's pretty much it.
That's all I have, Your Honor.
All right, Mr. Davidson, you stay down there. You said he signed up in 11/1 of 23.
That's correct.
All right. How many does your records indicate how many times he showed up and talked to you?
I mean, I could go back and look and see how many actual face visits I had with him. I did communicate with him. He was in the process of that.
So is it fair to say that he was showing up when he needed to and at a fairly consistent basis for a while?
Initially.
Okay. And so then when was he violated the first time?
that was, first violation was January the 30th, 2024 for absconding.
So 11/1/23 to 1/30/24, he was in compliance.
Yes, he, until the transfer was denied.
Do you have any idea? You have no idea why Kentucky would deny?
Well, based on the interstate compact offenders transaction system, they went out to do a home visit at his known address there in Auburn, Kentucky on 11/30/23. Let me just read it. It says, transfer denied by the state of Kentucky, as offender has called his Kentucky officer on 11/13/23 and advised he no longer wished to live at this listed home place. So I guess the officers in Kentucky, they went out to do it, and they said that he wasn't living at the address, and so they denied the transfer from the state of Tennessee to Kentucky.
Okay, and then what was that address? Does it say?
2601 Cemetery Road, Auburn, Kentucky, 4222206.
Okay, so did you have a problem with Mr. Skipworth going to Kentucky? Would it have mattered to you?
No.
You didn't care at all?
But that's where, no.
Do you typically go against probationers that need to transfer?
No, that's part of the process. If they reside there, we would just transfer their probation to that state.
Because that's where he was living.
That's correct.
So, and did you have an address here?
Well, the second time I did, when he was reinstated, that's when I did the second violation. He went into the Pleasant View. That address was 811 Walters Harris in Pleasant View, Tennessee.
Okay. And you couldn't find him there?
Yeah, and again, he knew not to leave the state of Tennessee unless it got approved. So he knows about the process. So after I did the home visit, I just filed a violation.
But you can understand why he would want to get back home and kind of being a little hamstrung here in Cheatham County, not really living here.
That's correct.
So then you mentioned something about him serving a year. That was for an FTA in Kentucky, you said?
Yes.
Okay. So been on since 23, it's 2026. Well, halfway, he's effectively, 2.5 years on probation? Is that right?
Scott. Roughly.
Okay. And so one of the years he's been incarcerated, and then he was reporting for some of the time before, correct?
I lost contact with him around February. I did the 2 home visits on February the 13th and the 20th, 2025. After that, he was going in the wind. I had nowhere he was at.
Are you opposed to Mr. Skipworth being reinstated and let's try this Kentucky process over again so he can get out and work and live where he lives? Would you be opposed to that?
He's not successful on probation. Opposed to being supervised by state of probation because he knows the rules and the.
I'll pass, Judge.
Repeat what the last thing. Were you opposed to him being reinstated?
Yes, to be placed back on state probation because he cannot follow the rules.
Would you be opposed to a transfer to community corrections? That's a little more demanding of Mr. Skipworth.
I have no problem with that.
Okay, thank you.
All right, thank you, sir. You may step down. All right, next witness. State has rested their proof. Mr. Vaughn, do you have any proof you wish to offer?
I'll call Mr. Skipworth, Judge.
Mr. Skipworth, if you'll come around, have him come around this way. Raise your right hand and be placed under oath.
You solemnly swear to affirm testimony you give the truth, the whole truth, and nothing but the truth. So help you God.
Yes, ma'am.
Okay, Mr. Skipworth, would you state your full name and spell your last name for the record?
Raymond Daniel Skipworth, Skipworth.
Okay, so Mr. Skipworth, you heard what Mr. Davidson had to say.
I did.
And You were reporting to him for a
I
brief amount
was.
of time.
The first violation, I went seeing the PO, and they denied my transfer the next day.
Okay.
So I didn't even have a chance.
So did you? Where were you living here?
I wasn't living nowhere here. I was
How-
staying at my father-in-law's, which
Okay.
is a one-bedroom house. He's got an invalid wife and her daughter that lives there.
Okay.
I was sleeping on the porch and in a vehicle,
Okay.
and I had a house in Kentucky.
That you own?
No, it was my fiance's mother's.
Okay. But you were allowed to stay there.
Yes.
That was where, is that where you're from?
No, I'm from here.
Okay.
But since 21, when my dad passed away, I've been living in Kentucky.
And is that the Cemetery Road
Yes.
address? Okay. So there were multiple people in there, and then Mr. Roderick said that you did not want to live there anymore, and that's why you were denied.
I never said that.
Okay. But that was going to
The
be your-
probation officer never came out there the first time. And
Okay.
They just denied my transfer.
Okay. So
Because the probation officer, there was a lady there that worked with my fiance, and she didn't like me
okay. So
for some reason.
all right. So then you get violated, and at what point does this FTA in Kentucky come up?
It wasn't FTA. It was a violation. I'm
Okay.
on probation right now, still in Simpson County. I was on probation in Logan County.
What?
Plus here, that's 3 counties.
So what in Simpson County?
They reinstated me.
All right. Are you reinstated in the other?
The other one, I
Flattened?
did so much time on it. I only had like a couple months to kill the year, so I went ahead and did it.
Okay. So that's what you've been doing.
Right. So I'm
Okay.
so I'm not on probation in that county. I took care of that. That way, I didn't have all this over my head.
So so Cheatham County is the only place hanging you up?
Yes.
All right. So would you be opposed to going to community corrections? It's more difficult, but if this judge gave you that opportunity, would you be able to be successful?
As long as I get to go to Kentucky. I don't live here in Tennessee.
Okay.
I've got a halfway house that's called Ally
Okay.
in Eastern Kentucky. All I got to do is call them, and I've got a bed waiting on me. I've
Okay.
got a job waiting on me in the mines and everything.
Okay. So this is holding you up from just moving on with
Yes,
your
sir.
life.
It is.
Okay. And
I've done
how
gave
long
my-
is your sentence?
This sentence is 5 years.
Okay. So you've got a halfway house, or is it some sort of rehab program?
It's a sober living.
It's a sober living facility,
Yes.
and it's called Ally
Ally
in what
Eastern Kentucky.
Eastern Kentucky.
Letcher County or Whitesburg.
So you heard Mr. Roderick say that you weren't able to be successful on probation. You would disagree with that because you were just trying to go home.
Exactly. I mean, you can't keep sleeping on somebody's porch or in their vehicle. You know what I'm saying? When they only have a 1-bedroom house.
Okay, so if this
It
judge,
makes no sense. I kept telling them I was homeless. That wasn't my home. It was just an address I could use till I could get up there.
right? Just a
which
landing
wasn't
point.
supposed to take over 2 weeks. You know what I'm saying? But
Right.
it continued on to 2 to 3 months.
Right. So it was just a jump point. It was never intended to be a permanent
Right. No,
residence.
it was
So
my ex-father-in-law's house.
what's the Pleasant View Walter Harris Road?
My
That's
ex-father-in-law's
it. That's the
yes.
house.
Gary
Okay.
Parman's house.
Okay. And there were 3 people living there. You said.
Yes, there's 3
Okay.
people living in a 1-bedroom house.
Okay. So if this, why should obviously
I've done changed my life, gave my life to God and everything. So
well, so
you
this
know,
is
it's up to y'all.
so this is the second violation. Tell this judge why you can get it right this time.
Because I never tried to violate before. I couldn't continue to be homeless. I mean, it don't make no sense to be homeless when I have a home up there.
I understand. All right, I'll pass the witness, Judge.
Mr. Willoughby, you may cross-examine.
Mr. Skipworth, work me through this one more time. So when you signed up for probation originally,
I never lived here. I didn't live here. I was living in Kentucky.
You wait till he answers.
Oh, my bad.
You let him ask the question. before you
So-
start answering.
but you give them an address here.
No.
Well, then how did Officer Davis?
That was the second time.
Can I talk, please?
Yes, sir.
How did Officer Davidson get the Tennessee address?
That was the second time.
So the first time you gave him a Kentucky one.
Yes.
But that got denied.
Yes. I went up there to see the PO, and the next day they denied my transfer for no reason.
But Officer Davidson also testified that he informed you of this process whenever you signed up and got on probation. Is that true?
The first time, no. I told him, I said, I live in Kentucky. He said, okay, go up there and see your PO in Logan County.
Okay.
I did that.
And then they denied you.
And they denied my transfer.
And then you just stopped communicating with everybody.
No, I got violated and they come pick me up.
Okay. And then by the second time you get out, you give him a Tennessee address, still got the same problems.
Yes.
And does it get denied again?
It got denied twice, 2 more times.
Okay. And then
That's
so
why.
so you knew this was going to be an issue, and then he just loses contact with you?
No, I didn't think it was going to be an issue because it was a totally
It put you in jail
county.
the first time,
It was a
didn't
totally different county.
But it put the same issue put you in jail the first time.
Yes.
And you knew it was going to be an issue the second time.
I didn't think it was going to be an issue the second time.
What changed? Just like now, what has changed? What if you get out now and they won't transfer you to Kentucky? You're on probation.
They have no choice but to, because I'm going to a sober living.
Okay. Well, let's just pretend for a second they do. Then what?
If they do, then I'm gonna have to go to a sober living or somewhere here. I mean, till I can get up there.
And then, because Kentucky's the only state that you can live in.
No, but I don't live here no more. I didn't live here when I took the probation. I lived in Kentucky.
Well, you're the one that entered the plea, knowing what you had to do.
Yes, and I was also on probation in Kentucky.
Okay.
So I'm still on probation in Kentucky. So if I got probation in Kentucky, Kentucky cannot deny me to live there to do the probation. Right.
What are you on probation for there?
For a simple possession charge.
And then you got a failure to appear up there.
It was a violation. I was on probation in 3 counties. Here, Logan County, and Simpson County.
So here you're on for stealing. Then you got
Here it was a wrongful imprisonment. I was at somebody's house when they got arrested, and they took me too.
Well, I know. I'm just saying, but you're on probation here for stealing.
Yes.
And then you got a simple possession probation in Kentucky.
Yes.
And what's the third one?
It was a simple possession.
So 2 simple
drug charges
possessions.
for my girl.
And then
She
they got
was on
violated. Where's this FTA come up? A failure to appear.
It was a failure to appear on a driving charge, and I was not doing a year on that. I was doing the year on the violation. I had 3 for
the
one.
simple possession.
Yes.
But you did get a failure to appear on a driving charge.
Yes, that got throughout.
And that was in the state that you are.
Kentucky, yes.
Yeah. Why didn't you show up to court for that? It's in the state you want to live in.
Because I was already violated. I couldn't go to court because I was going to jail.
So you chose not to go to court because you didn't
charge,
want to go
yes.
to jail.
Yes.
So basically, anything you can say or do to stay out of jail, you'll do it.
No.
Okay. I'm gonna ask you the same question your lawyer did.
I mean, since 21.
What is different today that you can tell the court, me, anybody,
Because I
that
live
is
for God.
different? Because of God.
I've changed my life.
Okay. God was around the other 2 times, right?
Yeah, but I had a lot going on in my life. A lot of bad things happened. The way I lost my dad was rough. They found him unconscious, shocked him 19 times with a pacemaker and fried his brain.
I get it. My dad's dead too.
And I had to sign papers. I had to sign the papers to take him off life support and kill myself.
Mm-hmm. Yeah. My dad died of cancer.
And that took me to a different place in my life.
I'm glad you're better.
Redirect.
No, that'll be it, Judge.
When were you placed on probation in Kentucky?
April of 23, I believe.
April of 23.
Yes. Well, that's when I got the charge. But I had to wait until I got done here and come back up here to get put on probation.
And then
I never even got to start the probation up there.
You had these 2 attempted possession charges where you're saying
Yes.
that you took the charge for somebody else
Yes,
or
sir,
your
I did.
girlfriend or whatever. When were those?
One of them was April of 23, and then one of them was the day they arrested me on the violation because she had 2 kids, and I didn't want her to get in trouble, and I should have never took them for her. But that's neither here nor there.
All right, step down. Mr. Bond, you have any other proof?
I do not, Judge.
Any rebuttal?
No, Your Honor.
We're here to do an argument.
I think Your Honor is pretty clear on my position. I just don't think he's proven he's very incapable of showing up for probation here or apparently in Kentucky too. He's had this strike 3 as far as state's concerned. So just put his sentence into effect.
Well, Judge, I'm sympathetic to Mr. Skipworth's situation. I can see how that could be a tough spot, just in the sense you have a home. It's not like it's across the nation. You've got the state of Kentucky just being the end all beat all of decisions as to whether or not he can come back and live in the country or in the county. And he was just trying to get to his home where he has an established life, he has a job, and he can be able to kind of, so to say, put the wheels back together on all this. Sounds like he's been proactive in procuring himself a halfway house and has a plan. I think that if we can transfer him to community corrections, require, let's try to transfer to Kentucky again. I'm not sure what keeps getting hung up there and why Kentucky's so adamant about, and I'm sure it's probably just a caseload situation. But
Could be because he's got 3 convictions in the state of Kentucky. They don't want him back.
it could be that, but I can understand if he's truly living on a porch and living in his car and just trying to get home. Judge, I'm sympathetic to that fact, and I think that maybe Mr. Skipworth needs another shot. It is not as if it was, more drug charges or any kind of. It really was just him trying to get home. Were the reasons for all the violations. So I say we let Mr. Skipworth go back to Kentucky.
Mr. Skipworth had been given a number of opportunities. Number one, he was charged with felony theft here in Cheatham County, Tennessee. Whether he was living here at that time or living in Kentucky doesn't matter. The crime was committed here in Cheatham County, Tennessee. He admitted that and was entered a plea before Judge Lockhart Mash and was sentenced to 5 years in the Tennessee Department of Corrections. He was ordered to pay $6,500 restitution, and that sentence was suspended to probation. He then, that occurred in, appears to be October the 31st of 2023. His first violation of probation occurred on January the 30th of 2024. And I say that first violation, that was the first warrant that was issued by me because of the fact that he had failed to report back to Officer Davidson after he had been denied the interstate compact offender transfer. So he was arrested then. Actually, he was sought to be, and I had a hold for hearing on him at that point. But even on, apparently wasn't charged or wasn't arrested, at least immediately, because on March the 28th, Judge Larry Wallace issued another violation of probation, basically on the same basis that he had confirmed that he was not reporting to the state of Tennessee because the transfer was denied, and they had attempted to contact Mr. Skipworth. So then he comes to court, and that's in front of me on July the 30th of 2024. I heard his violation of probation, and he pled guilty. The violation of probation was based upon the fact that the subject was directed to report back to the state of Tennessee after the interstate compact offender tracking system transfer to the state of Kentucky was denied on 12/14/23 and 1/2 of 24. He conceded the violation of probation and was reinstated to probation by me. So then we come forward and we have this new violation, which was taken out on February the 25th of 2025, which again shows an attempted visit with him at his Pleasant View address that he had been given on several occasions, and he hadn't reported and basically had absconded. One of the principles of probation is that a probationer, a person convicted of a crime, theft is a serious crime, person convicted of a crime doesn't get to choose what they will do or not do. They have to obey the rules of probation, or else there's no reason to have them on probation. In this particular situation, I understand Mr. Skipworth says he doesn't have a place, he doesn't have a residence. I would beg to differ. He does have a residence. He has a residence in the Cheatham County Jail. He has a residence in the Department of Corrections of the state of Tennessee. And it is to that residence that I remand him because I find him in violation of probation, and I revoke him to serve his sentence, the balance of his sentence. And Tennessee Department of Corrections are providing in place. That's the judgment report. He is in custody to serve his sentence. Mr. Skipworth, you need to step back, officers. Mr. Fuson, are you ready on yours?
I'm ready, yes, Your Honor. Just waiting for Mr. Mayor to brought up.
Mr. Victory's sitting here. Mr. Victory, yeah. I looked through his file. I have no objection to what he's asking for to terminate early. I think he's done fine thus far. It's not too early.
Sentence is still in effect. It's just the probation is being terminated. All right, I'll grant that request with the state's permission. So,
You good? I'll come back here. Do I need anything? Just
need to make sure that the probation officer talk to them and make sure they understand that you're being terminated. Tell you what we need. Need to get some of those hand warmers like they have for football season, and the kind that you can just kind of squeeze and hold on to. Because I swear my fingers are starting to lose. All right. Who do we have here?
Arthur Patterson, Judge, I'm sorry.
All right. Mr. Patterson's charged with probation violations. The state ready?
Judge, just talking to Mr. Patterson, he's serving a 6 out of TDOC at 100%. He's just brought that idea of just putting this into effect because this is an 8 at 30, I believe. So if he's going to be in the TDOC for 5 more years, he's just going to lay it down.
Makes sense to me, but I mean, you want to make sure it's okay with your client.
That's what it was his idea.
All right. Well, if that's what he wants to do, come on up and we'll take care of it. You have a good lawyer, Mr. Vaughn. I've known him a long time. He's always advocating for his client's best interest, and he was prepared to give you a hearing today, but he says you've indicated to him you'd like to just go ahead and put your sentence into effect. Is that correct?
Yes, sir.
All right. Raise your right hand. Let's place you on the road.
I do.
All right. State your full name for the record.
Arthur Frederick Patterson.
Mr. Patterson, you're here today on a charge of probation violation. Do you understand you have a right to plead not guilty to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes, sir.
Do you understand you would have the right to have a lawyer and have one appointed if you cannot afford your own, which I've done with the public defender?
Yes, sir.
Do you understand if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and you could have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty to this charge, you're waiving your right to that hearing and to the appeal? All I'm going to do is approve what your lawyers worked out, or rather what you've requested, and that is to go ahead and revoke you to put your sentence into effect with all of the credits that you're entitled to.
Yes, sir.
Do you understand all of this?
Yes, sir.
Do you wish to plead guilty according to that understanding?
Yes, sir.
And upon your plea of guilty, I find you guilty, order that you be revoked to serve your sentence with credit for all your time. All right. Good luck to you.
All right, good luck, dude.
Did y'all have some other visiting to take care of?
No, he just told him to sit down.
Okay.
I figured I would since we were just waiting.
Thought maybe I missed something. So.
No, just chit chat now, Judge.
All right, what do we have next? Anything? This Mr. Fuson keeps coming and going. So.
I think he's just waiting on Mr. Mayo.
Do we have anybody else after Mr. Mayo?
I've got James Street that should be back there. I think that we're waiting on him.
Jeremy Greenwood is for plea, but his lawyer. We're good.
Mr. Northcutt has joined Elvis and left the building, I believe.
Yeah.
Should have said it.
I knew exactly. I knew exactly.
I guess you want Mr. Street next.
Yes, that'd be great, Judge. We're ready on him too.
Other card.
Is that the only trash? Let me get more.
What are you doing? What is that?
Cough drops.
All right, toss one of them up here. Thank you. I can't believe as much as I've coughed and struggled to talk that you all hadn't offered that.
Pretty rude.
Julie said she was trying to get me one and you would take it away from her, wouldn't give it to me. Thank you for your consideration, Julie. All right, this is James R. Street, is that correct? It's for probation violation hearing. Stay ready.
Yes, Your Honor.
All right, defense is ready, obviously, so let's call your first witness.
Officer Davidson again. Oh, Eric, I'm sorry.
Tinsley, if you'll step up, raise your right hand, let the clerk place you under oath.
You solemnly swear to affirm testimony you give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Apologize for almost skipping your opportunity to testify in this brand new facility.
Oh.
Could you state and spell your name?
It's Erica Tinsley, Tinsley.
And where are you currently employed?
Tennessee Department of Correction, Probation Parole.
And what's your position there? Like, did you
I'm
just get a promotion?
I'm a probation parole officer supervising 3.
And are you in charge of supervising Mr. Street?
Yes.
When was he placed on probation?
February 10th of this year.
And how's he been doing since?
I do not know. He's never reported to me outside of a text.
Okay. When was he incarcerated when he was placed on probation?
He was incarcerated, yes.
And did you meet with him at that time?
I did.
Was he informed of all the rules and everything?
Yes, sir. We went through all the paperwork to sign up for probation, and he had given a Kentucky address. So I explained the rules of transfer to him, that he wasn't going to be allowed to leave the state until he got at least reporting instructions, which take 48 hours to receive a decision on that. And that in that time, we would get him into intake. He was scheduled an appointment for February 12th for intake and never reported to that.
What efforts did you make to locate him?
I contacted him via phone because he's got a Kentucky address. Obviously, I can't ride up to Kentucky and try to locate him. I did, however, speak to an officer in Kentucky that was also looking for him, saying that they hadn't seen him at the address that he had been.
So we're learning a lot about transferring to Kentucky today. Was his transfer approved?
His transfer never even got started. The way that the ICOT system works is that if they're a resident of the state, when they're convicted here in Tennessee, we can request reporting instructions. The sending state sends those. The receiving state has 48 hours in order to respond with a approval or deny. Once that's approved, then the offender can go to the state legally. At that point, the sending state submits a transfer. That transfer has then 45 days to be investigated by the receiving state, at which point they can do a denial or an approval.
So if I think I heard you right, in between the request and the end time of 45 days, they're given a person in that state to go see.
Yes, if they have approved reporting instructions, they are given an officer to go see.
But that wasn't the case with Mr. Street.
No, sir. He was released out on the 10th. He contacted me on the 11th that morning. I got him set up for an intake on the 12th because it was the very next day. So reporting instructions were requested but never responded to because he disappeared the next day.
How did he have an officer in Kentucky? Was he also on probation there for something different?
No, I'm not sure if it was a probation officer or if it was a law enforcement officer that had contacted me, but he did state when he was filling out his probation paperwork here that he had pending things in Kentucky.
Okay, so somebody with law enforcement in some capacity was looking for him.
Yes.
But he had no person to report to.
No.
You mentioned some text messages or phone conversations that you are kind of counting as reporting. If you could tell the court what kind of communication, if any, you really had with Mr. Street.
When Mr. Street was released from Cheatham County Jail, he texted me to state that he had been released. I got him at that point an intake date about 5 minutes later and texted him back and said, "This is your intake date. It's tomorrow. You're going to be here at 9 o'clock for intake." And
that's the last time you talked to him?
That was the last time that he responded. After he missed his intake date on the 12th, I texted him back saying, "You missed intake. What's going on?"
And nothing.
And then nothing.
You said he responded to your initial, I guess, schedule.
Yes, he did respond to the initial scheduled appointment. Said, "Got it."
Did his so his response
was
acknowledged he understood and received the message?
Yes, sir.
Anything else you need to tell the court?
That is all I know of Mr. Street.
Thank you.
Mr. Vaughn?
Good afternoon, ma'am, or morning. I'm not sure which it is. So he started with you on February 10th of this year.
Yes.
When was he released? Do you know?
On February 11th.
Okay, so the next day. How was the conversation? Did you learn anything about Mr. Street in your initial? I assume he pled over there, and then you went back and were told to him and talked to him.
Yes, sir.
Did he tell you anything about where he was living or how he was living? Or
no, he just gave me an address in Kentucky. He said that was where he was going to be residing, and that is an address he had lived at prior. He did not give me a phone number because he said he didn't have a phone. And when we were discussing things and explaining everything with each other, he did say that he had pending charges in Kentucky.
Okay. So he was probably, he had to go to Kentucky for that anyway.
Yeah.
So, and you waited until when did you file the warrant for the violation? April 14th of this year?
Yes, sir.
It's about 2 months it passed.
Yeah.
And how many text messages were back and forth?
That were back and forth. There was 3. That
Okay.
was 2. There was 5 or 6.
Okay. And what did you say the responses from him would look like?
The first response or the first text he sent me, he initiated the conversation when he
Okay.
got released from Cheatham County Jail. The next text from him was "Got it" when I gave him the intake date. And that was the only 2 texts that I received from him.
Okay. So this is his first violation. Is that correct?
Correct.
Okay. Any opposition of Mr. Street trying this again? Are you staunchly opposed to that, or
No.
you give him another shot?
Yeah. This was a situation that could have been avoided.
Right.
He can still redeem himself by reporting.
And you'd be all right with that?
Yeah.
Okay. I'll pass it.
Thank you, ma'am. You can step down. State is rested to approve, Mr. Vaughn.
I'll call Mr. Street, Judge.
Mr. Street, come around. I think for future reference, at least for my court, we're bringing a defendant around, bring them around that way. That way, don't have to go behind the district attorney's office.
Yep, that seems prudent, Judge. It might get rejected.
Mr. Street, raise your right hand and face our court.
You solemnly swear and affirm the testimony you give will be the truth, the whole truth, and nothing but the truth.
Have a seat.
All right, Mr. Street, state your name, spell your last name for the record.
James Robert Strite II, Streit.
Ah, so it's Strite. I've been pronouncing
Yes, sir.
it wrong. All right, my bad. So you heard what your probation officer said. What happened, man?
Well, basically on the 10th, I do have another case in Kentucky that I was supposed to go finish. I was supposed to turn myself in a bear. That was the plan. At the same time, I don't want to give y'all a bunch of bull sugar, but I'll just cut to the chase and, say what I can. I got out here. I wasn't supposed to leave the state. My sister and my partner was sick. She's also 9 months pregnant, so she couldn't come and take me to Clarksville 2 days after I got released. So I stayed under this bridge down here, right down the road, literally by the river, until Wednesday night. I was going to walk to Clarksville. I ended up taking the train tracks. I walked to Nashville. My phone, I think I sent her a couple messages. At the same time, my baby mom's going through pregnancy. She's moving. So I end up quit worrying about that. I'm stuck down here for a week in Nashville. I end up going to help her and get moved into the new house. And I got 3 daughters, and a new one. So I got them settled in and went up there. I didn't end up turning myself in or going to report. But after I got all this taken care of, I ended up finding a job. I worked for a little bit. And once I was comfortable with them being settled in, I turned myself in.
So you turned yourself in on this violation?
Yeah, I notified the authorities and told them that I had a warrant and that if they wanted me, they said, yeah, we'll call and see if they want you, we'll come get you.
Okay. If this judge, tell this judge why this opportunity would be different this time. What's changed in the past 4 months to make us?
Well, I mean, I worked and did everything I would have done normally. I got a job roofing while I was up there at Pay Cash. I saved up $750 for my restitution and court fees. I realized I didn't do the most honorable thing to turn myself in, but just in my mind, that was kind of everything just happened at once, and wanted to make sure everything was situated. But
are you going to be able to do it this time?
Oh yeah, and I've signed the extradition, so they'll come to get me. So they'll supply the ride this time.
Well, that'll be good.
She's settled in. I got a place to stay. It's beautiful.
Where would you be living?
Missouri.
Missouri. Okay. You understand, as we've understood from a previous hearing, you can't go anywhere until the transfer stuff happens.
Right.
No matter what.
Yeah.
Are you going to be able to report to her?
Yeah,
until that happens?
I won't be leaving. I'll be waiting on Kentucky to come get me.
Right. And then what's waiting for you in Kentucky?
I'll probably do a couple months there. Or I'll be reinstated on probation there. And then from there, I'll be going to Missouri.
Okay. And what is the first thing you're going to do when you're released from Kentucky?
I'll go to Missouri.
No.
Report?
Yeah.
Or call, let them know.
Mm-hmm.
Yeah.
Okay. And you think you can get...
You want to write it down for him?
Right. It looks like he's got some space on his face for it.
Yeah, I do. I got it.
Okay. But you can do it this time?
Yeah, absolutely.
Okay. And we won't see you in here again?
Y'all won't see me again. I might write you a letter telling you thanks.
All right. I'll pass it.
Okay. What charges do you have in Kentucky?
It's an assault charge, actually.
Stood up a little bit.
It's an assault charge.
And have you been found guilty, or is it still?
Yeah, I've already got time on it.
Okay.
Yeah.
Well, how much time do you have up there on that?
10 months.
So it was a misdemeanor.
Mm-hmm.
Now, but beyond that, your criminal history is. Have you been in and out of jail before?
I have. I mean, I've got a pretty extensive record, but I mean, most of it's alcohol related, speeding, tickets, stuff like that.
You've been on probation
I've got a couple.
before?
upward charges, but I mean, I have done good on probation before I've completed it. My probation officer, I mean, they're good people.
Okay.
I'm usually pretty.
I'm just saying you've been on probation before, so you know
Yeah,
the rules.
absolutely, yes, sir.
And you said you had a phone whenever you got out this time.
I did, but I don't have Wi-Fi, so.
Would it call, or did
Yeah.
you have to get on Wi-Fi to
I had
call?
to go to Wi-Fi, replace with Wi-Fi to use it.
But you had that enough to contact your probation officer a little bit.
Yeah.
Why didn't you? I mean, you
Well,
just got out of jail.
Yeah, well, after, not making it to Clarksville and not being able to go to Clarksville, and then thinking, well, okay, I'm stuck here. I'm not gonna be able to get to Clarksville. I've got nobody to come pick me up. I've got a pregnant girlfriend that's about to have a baby right now, and it just.
So you knew what was going to happen. You're just trying
I
to
was
punt
like,
it
well,
down
I
the
really,
road.
and on top of that, I'm sick, and my agnoids are like golf balls. So I'm like, well,
You're what?
Like my lymph nodes were swelled up.
I
like
thought
the
you said
size of golf
agnoids.
balls. Agnoids, I think it's.
Is that real? I don't know what that means.
It's your lymph nodes.
I'll take your word for it.
Yeah,
but
it was a rough time. It was a rough week. Yeah,
but that's better now.
Yeah.
What's in Missouri?
My partner, my baby's mother.
And you have how many total kids?
3.
With her, including one that's pretty new.
Yep, she's 6 months now.
Okay. I don't have any other questions, Your Honor.
Or 4 or 5 months.
So do you have any pending cases in Missouri or
No,
just,
no. I have no pending cases at all whatsoever.
So you didn't live in Kentucky either?
No.
You just got in trouble in Kentucky?
Yeah, I was supposed to turn myself in up there. That was the plan.
But if I put you back on probation, you still are going to be held because they've got a detainer warrant
Yeah,
on you.
they'll come to get me, and then I'll finish out whatever they want me to do, and then from there I'll be, if they approve it, going to Missouri. If not, I'll be going to a rehab.
I will say I was informed by probation, just for everybody's future knowledge. If you put someone on community corrections, evidently that will not transfer.
That's what I thought too. So. How old are your children?
My oldest just turned 4. She's going to turn 5 on the 25th this Saturday. Got another one's 2.5, and this new one.
When's the last time you saw him?
The day before I turned myself in.
Day before
Which I
you
was
turned
with him every
yourself
day. I
in?
stayed with him every day.
Where in Missouri are you talking about?
Cape Girardeau.
Where?
Cape Girardeau.
Been there. Step down.
Yes, sir.
Anything else, Mr. Bond?
I don't have anything else, Judge.
Mr. Willoughby, you have any rebuttal proof?
No rebuttal.
Want to be heard?
I don't know what I'm supposed to say to this stuff. I mean, when you just don't show up and everybody's got a million different excuses, it's hard for me to just agree to reinstate someone. I understand things happen, but I think things have been happening and continue to happen with Mr. Street. It sounds like if he were to get out, it still has a complicated equation about how to get to Missouri and handle Kentucky.
So
and
what you're
here.
saying, your argument is it's an exercise in futility.
Yes, 100%. Thank you. That's all.
I don't know that it's an exercise in futility. I think that there are just a couple of hoops we're going to have to jump through. So, we've seen people here today that have had multiple shots of the apple here. This is Mr. Streit's first. I believe him when he says he's got a plan.
Is it Street or Strite?
It's Strite. I've been saying it wrong too. I believe him when he says he's got a plan. If he's got a better situation now and understands that, this is serious stuff, and we're gonna have to figure out how to make it work. If I think Mr. Strite should get another shot at this and see if he can he can put it all together. And if he can, then that's wonderful. And he can't, we'll just see him again soon. But I think that looking at his charges, I believe it's theft. I don't think that his criminal history is too extensive. I think that he would be another candidate. He's been in since, as he said, he turned himself in. He's been in since 6/18. I think that that's plenty of time to kind of shake some things loose. And I think that that's a good learning curve, 40 something days. So I would argue that Mr. Stripe deserves just at least one more shot. And if it doesn't work out, then we know what's going to happen the next go around.
Shake some things loose. Let me say this. I'm all for giving somebody an opportunity to prove themselves. Mr. Stride obviously did not do a very good job of proving himself so far, but this is his first violation. His probation officer indicated she was willing. She thought he might do okay to putting him back on probation if he would just report. He's been in jail for some 30 days. He has 3 children. I have a feeling that if I replace him with probation, that Kentucky's going to take care of our problem for us by probably transferring him up there on their warrant. And I make mistakes all the time, but I'm going to grant Mr. Strite an opportunity to take care of his children by returning him to probation on time served. He'll be held until Kentucky extradites him if they choose to do so. But he will not be allowed to transfer his probation to Missouri until they approve it. And that is still not a very sure thing, obviously, based on what we're hearing. So I'm going to order that his probation be reinstated on time served and extends his probation for a period of additional 1 year. So that means you're going to get a year added to your sentence. But I'm giving you an opportunity to go take care of your kids if you're willing to do that. So, all right, that's judgment of the court. What else do you have?
I believe that concludes my business with the court, Judge. What?
I'm ready when you are. We have a sentencing hearing set for 1:30 out of Dickson County that we're going to conduct in this courtroom. Mr. Lockhart, why are you hanging around?
Well, I'm just waiting for the court to take up Mr. Greenwood and Northcutt.
Are they in custody?
Mr. Greenwood is. Finally made contact with him. It's Jake Lockhart's case. It's here. It's a pleasure of the court. Jake Lockart.
Well, let's get Mr. Fuson taken care of. And Holly, Mr. Fuson will not be on our list of appointed attorneys. I don't know if you've already moved him or not, but he's assisted us in taking appointed cases in the past but cannot continue to do so. All right.
Turn this in.
All right, we have Mr. Roy Mayo, and showing that he's going to be entering a plea of nolo contendere to count 3 arson and receive a sentence of 6 years at 100% release eligibility to serve in the Department of Corrections, but that would result in all remaining counts of that indictment, and I'm talking about CR 19423, and it would also result in 19424 being dismissed entirely. So all other charges he has pending would be dismissed as a part of this agreement. He would get pre-sentence jail credits from August 12th, 2021 until today. Is that correct?
That's correct, Judge. And Mr. Mayo wanted me to bring up to the court's attention. After I met with him last time, he had a question about what kind of potential good behavior credits he may get while he was here in your facility, apparently for the last almost 5 years. I talked to the lieutenant, He assured me that he would be checking whatever boxes he's able to check, but ultimately be up to TDOC. I've explained that to Mr. Mayo, and he wanted me to just bring that to the court's
The
attention.
Department of Corrections is the one that controls the good time credits and things. I don't have any control over that. So we will give you the time that you've served here as a pre-sentence jail credits, and hopefully that'll take care of it. Mr. Mayo, raise your right hand. Let's place you under oath.
Yes.
All right, thank you. State your full name for the record.
Roy Daniel Mayo.
Mr. Mayo, I want to make sure you understand your rights. You've heard me go over what the agreement is, but have you seen or been shown a copy of the charges against you and gone over it with Mr. Fuson so that you fully understand everything you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere. All that really means is you're not going to contest the state's evidence, but you're not going to admit you did anything. And I will use the state's evidence, they tell me, to support a finding of guilt in this case. Do you understand that?
Yes.
Do you also understand that you have a right to plead not guilty to all charges and have a speedy and public trial by jury in this court?
Yes.
Do you understand you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes.
Do you understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes.
Do you understand that if you went to trial, you and Mr. Fuson could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena?
Yes.
Do you understand you would be presumed to be innocent? You would not have to testify or prove anything at trial, and no inference of guilt would arise because you did not testify at your own trial?
Yes.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by entering this plea of no contest, you are waiving your right to a trial and to an appeal?
Yes.
And all I'm going to do is approve what your lawyer has worked out with the state. Do you understand that?
Yes.
You also understand that's going to result in a conviction. That conviction will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes.
Do you understand everything I've explained to you?
I do.
Do you want to waive your right to a trial by entering this plea of no contest?
Yes.
Is your decision to plead no contest today voluntary?
Yes, it is.
Anybody forcing you to do this against your will?
No.
Do you understand I cannot accept your plea unless I'm satisfied that you are in fact guilty of this charge and there are facts to support it?
I understand.
Then listen as the state tells me what their evidence would be if this case went to trial.
Yes, Your Honor. In docket 19423 on December 12, 2020, officers responded to 1665 Bearwallow Road here in Cheatham County. The report, the complainant stated that she heard something outside, went to her door, encountered Mr. Mayo. He demanded entry into the home. Once he got into the home, caused some fire damage in the kitchen. She exits the home, tries to wave down a patrol car, calls 911. That patrol car, I think, does a U-turn and gets back to the residence. At that point in time, Mr. Mayo exits the residence, gets in a vehicle, is pursued all the way to Montgomery County where the pursuit was terminated. He was subsequently picked up on these charges, but those would be the facts.
I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be at trial.
I'm sorry. There was some fire damage in the kitchen area that she stated he caused to the home. So I forgot about pretty important.
Are you satisfied with your attorney services?
Yes.
You feel like Mr. Fuson's done a good job of representing you competently?
100%.
Mr. Fuson, do you know of any reason you should not enter this plea?
I do not, Your Honor.
Then Roy D. Mayo II, upon your plea of no contest in 2023 CR 19423 to count 3 arson, you're found guilty, sentenced to 6 years, Tennessee Department of Corrections at 100% release eligibility. You are also, the remaining counts of that indictment are dismissed along with case number 2023 CR 19424. You're entitled to pre-sentence jail credits of August 12, 2021 until today. Thank you.
Thank you, Judge.
Thank you.
All right, are we ready on Mr. Lockert's cases? Are those the only ones we have left? Which one do you want to take up first, Mr. Lockert?
Thank you, Judge.
You're welcome.
Yeah, I understand that Mr. Northcutt is also on Jake Lockert's list of cases, and I understand from Miss Sylvie that they're going to be moving that to the next VOP date.
Not particularly. So, Mr. Northcutt had filed a motion to withdraw his plea. We came to court and Mr. Lockhart was going to talk to him about it. We reset it to today. And then the victim is here. And Mr. Northcutt left because Mr. Lockhart told him I had agreed to a continuance, which was not particularly the case.
Not this
Lockhart, the one that isn't present.
Did I take the plea?
Yes, Your Honor. So I guess we'd have to set it to November if we're going to have another date. I don't know if it was set for trial. I hate to set it for trial again. But
I mean, he's pled, right?
He
And
has.
He's just asking to withdraw his plea.
Yes.
And that burden's on him to show a reason why he should be allowed to withdraw his plea.
Correct.
So I'm not inclined to set it for trial until after that argument.
I agree.
That motion is heard.
And they bear the burden on that.
Would you have any opposition to moving it to another county?
I don't know that she would want to travel to another county because she's been appearing. The victim has been, Miss Barnes, and she's in the courtroom.
Well, I was going to offer that. I've got some motions set in other counties that we could set it on one of those days, but obviously, do you want to wait and see if Mr. Jake Lockhart appears? Because if Mr. Lockhart appears, even if his client's not here, we can go forward with that motion.
Is he going to be? He told me he wouldn't be here until after.
My understanding, he's in Waverly. He's behind 3 hearings down there, whoever's doing those.
Well, I have a sentencing hearing at 1:30 here for State versus Rebecca Miles. That's out of Dickson County, and I don't know. I'm understanding that's going to be fairly lengthy. Well, General, what do you want to do?
Your Honor, if we, let me ask her real quick. Your Honor, we'll just set it on the court date in November, keep it in this county. I believe one of the issues is the monitor. He's required to wear it while it's pending, so we'll stay there.
November the 10th.
Thank you.
Right. I'll let Jake Lockhart know, Your Honor.
Right.
Then the remaining plea for him, I understand, is going to be Mr. Greenwood on page 3.
We need to bring out Mr. Greenwood.
Hopefully he's up here. Okay. I need you to sign right there. Right there. Okay. Your Honor, this is Jeremy Greenwood, page 3, in case number 19797. It's my understanding that in this particular matter, Mr. Greenwood is going to plead to count 1, possession to Schedule 1 for resale, Class B felony, 8 years on state probation as a range 1 offender, dismissed counts 2 through 4 in settlement, and mandatory minimum fines and cost.
All right, Mr. Greenwood, raise your right hand. I'm going to ask you to step in front of that microphone. Let the clerk place you under oath.
Yeah.
Thank you. Put your hand down. State your full name for the record.
Jeremy Eugene Greenwood.
And you can just stand right where you are, right there. You have been charged in an indictment of 4 counts. It looks like that you're entering into an agreement to plead nolo contendere to count 1 and have the other counts dismissed. Do you understand that a nolo contendere plea means you're not going to admit you did anything wrong? but you're not going to contest the state's evidence when they tell me what their evidence would be. And that evidence will be used by me to find you guilty according to this agreement. Do you understand that?
Yes, sir.
Do you understand what you're charged with? Have you and Mr. Jake Lockhart been able to go over the facts of the case and discuss the range of punishment and any possible defenses you might have?
Yes, sir.
While it's indicated that you want to enter this plea of no contest, you can enter a plea of not guilty and have a speedy and public trial by jury. Do you understand that?
Yes, sir.
Do you also understand that if you went to trial, you would have the right to have an attorney to represent you and have one appointed if you cannot afford one?
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you also understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness that the state called, and you could bring in your own witnesses by using a subpoena?
Yes.
Do you understand you would be presumed to be innocent? At trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes.
Do you understand that if you went to trial, you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I do.
Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand all the rights that I've explained to you so far?
I do.
Do you wish to waive those rights to a trial by entering a plea of no contest?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
All right. Do you understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if you went to trial.
In docket 19797 on October 16, 2025, officers observed a vehicle that turned out to be driven by Mr. Greenwood with a window tint that was too dark. They initiated a traffic stop. When they were gathering Mr. Greenwood's information, another deputy noticed some drug paraphernalia in the vehicle. At that point in time, both the passenger and driver were instructed to get out of the vehicle. A probable cause search was conducted. There was a backpack behind the passenger back seat. Inside that backpack were several items of drug paraphernalia to include syringes, glass pipes, things of that nature. There was also some paperwork in there with Mr. Greenwood's name on it from Davidson County. 29 grams of substance consistent with heroin, 2 grams consistent with methamphetamine, and 9 grams consistent with marijuana. Those are all facts.
I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if you went to trial.
Yes, sir.
You still wish to plead no contest.
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Jake Lockhart has done a good job of representing you competently?
I do.
Mr. Eric Lockhart, do you know of any reason he should not enter this plea?
No, sir, I do not.
Anything further from the state?
No, Your Honor.
The Jeremy Greenwood in docket number 2025 CR 19797 upon your plea of no contest to count 1, counts 2 and 4 are dismissed. I find you guilty of count 1, possession of a Schedule 1 drug for resale, sentence you to 8 years in the Tennessee Department of Corrections. That will be suspended to state probation as a range 1 offender. You're ordered to pay the mandatory fines and costs. And anyone know what that is offhand? Is it $2,500 fine?
I believe that's right, Your Honor.
$2,500 fine and court costs.
The only thing I would say there that Mr. Jake Lockhart needs to enter the jail credits.
Correct.
On his plea sheet.
There'll need to be a separate order entered for your jail credits, but make sure you see the probation officer before you go back.
Okay. Yes.
So they'll come back and see. Anything else from the morning docket? So we are adjourned from Cheatham County via violation of probation at 1:30. We'll start holding Dickson County Criminal Court as we have a sentencing hearing in Rebecca Miles. Do you have that file, General, or is?
I do.
If you don't mind letting me have it so I can look at it over lunch, please. Thank you. All right, we stand at recess to 1:30.
All right.
All right, we're here on one case out of Dickson County Circuit Court, 2025 CR 59, State of Tennessee versus Rebecca Ann Miles. Is the state ready?
State's ready, Your Honor.
Defense is ready.
Judge, the way this courtroom is constructed, I may ask.
Well, I have a camera set up on the witness stand so that you'll be able to see the witness on the camera. But if you need to move, Mr. Flanagan,
Okay.
feel free to do so.
All right.
All right, this is a sentencing hearing, so the defendant, having entered a plea to a number of counts previously, for the record, she entered a plea on May 26th of 2026 to count 2 DUI, first offense per se, Class A misdemeanor, count 4 reckless endangerment of deadly weapon, Class E felony, count 6 child endangerment of a child less than 8 years of age, Class B felony, and count 8 felon in possession of a firearm involving a prior violent felony, a Class B felony. Counts 1, 3, 5, 7, 9, and 10 were all dismissed as a part of the agreement. And the agreement was that she entered a plea open and concurrent to one another, and the court would decide the length of the sentence between 8 and 12 years exposure. The manner of service at the future sentencing hearing would be classified as a range 1 offender. Counts 6 and 8 are subject to 40, 35, and 501. And then there's a separate case of 2025 CR 294 that was dismissed as a part of the settlement agreement. I've just read that from the waiver of rights that was entered, and I assume that is accurate, correct?
It is, Judge. And could I ask, I mean, she's got shackles on her feet. Does she have to be handcuffed like this in a sense?
I have no problem with removing her handcuffs in a sentencing hearing. So.
It's just easier to communicate with her. But she's got her ankles. Okay. Okay. Judge, and the main reason is we write notes back and forth, and it's easier.
I don't have a problem with that.
That way, if you have anything that you want to ask me, I have to pay attention to what I'm doing, so you can write it. Okay. Thank you, Judge. Thank you, officer.
All right. You wish to make an opening statement, or you want to proceed with your proof?
I can make it very brief, Your Honor. Your Honor, the reason I'm giving an opening is because we did not go through a trial, so I'd like to provide at least a factual foundation, very brief, before we go through the proof. With that said, Mr. Flanagan, would you like to go ahead and call the rule?
I would. I'd like to call the rule before an opening.
Rule has been requested, so if anyone who is going to be a witness that is not a party to this proceeding must go outside of the courtroom and remain outside of the courtroom until you yourself are called to testify. You're not to discuss the testimony of any other witness with anyone until you yourself have concluded.
And for the record, my first witness is going to be Officer James, and the state's affiant is Officer Lewis. That's why they are remaining in the courtroom, Your Honor.
Judge, and the officer can stay if she wants to. I just want civilians.
Officer Smith?
You don't have an objection to the officer?
No, I don't have an objection to Officer Smith.
Officer Howell, if you want to retrieve them.
Yes, sir. You should, I just meant civilians.
I didn't want to influence their
No,
testimony.
that's fine.
That's why I wanted to go ahead
That's
and do
fine.
it. Mr. Flanagan graciously said
you can
stay.
All right.
Your Honor, this case involves January 22nd, 2025. It's about 3:45 p.m. Miss Libby Sanders is driving a short bus that is ultimately held by a private school, Nashville Christian School, I believe. The bus is going down Highway 70, coming from the direction, I believe, of White Bluff, and it's in the left turn lane to get on Highway 96. This is the intersection of Highway 70 and 96. While the bus is in the left turn lane, you're going to hear testimony today from a witness who said that further up Highway 70, prior to this crash, a car was going in a very erratic manner all over the road, scaring this witness to where she ultimately had to accelerate to a high speed to get around this car. This witness then went to the intersection and I believe was in the left lane while watching a school bus in the left turn lane, where this car came around and struck the school bus at a high rate of speed. You will hear from another witness who's the opposite lane going eastbound on Highway 70 with his crew, where he sees this car come around the curve at a rate of speed either at or above the speed limit, not braking, coming to a crowded intersection, ultimately striking this bus. The bus then catches fire. It's hit in the back left corner, where ultimately a fire erupts, and the bus driver, Miss Libby, has to take a 6-year-old KO and run up a hill with him so that he is not injured by this fire. You're going to hear that inside of this car, owned by the defendant, Miss Rebecca Miles, is a purse which has a prescription for oxycodone, as well as a purple handgun. Miss Miles, previously known as Miss Rebecca Fain out of Montgomery County, is a convicted felon for an aggravated assault, making a possession of a gun a Class B felony. Those are the facts there which will be shown today, as well as all the other materials for purposes of enhancement factors and the discussions that we will have at the end for your sentencing consideration, Your Honor. Thank you.
Mr. Flanagan, you wish to make an opening?
No,
All
we're
right.
ready to go.
State may call your first witness.
State calls Wendy James.
James, if you'll step up, raise your right hand and be placed under oath,
Do you
please.
solemnly swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon, ma'am.
Good afternoon.
Please state your name.
Wendy James,
How do you spell it?
WENDYJAMES,
Where are you employed?
with the Tennessee Department of Correction.
What is your role?
I am the pre-sentence investigation report writer for the 23rd Judicial District.
Okay. Officer James, were you assigned to conduct a pre-sentence report for Miss Rebecca Miles?
Yes, I was.
And do you see Miss Miles in the courtroom today? If you need to stand, that's fine.
Yes, I do.
Where is she seated? What is she wearing?
She is seated over by Mr. Flanagan in orange.
Your Honor, if the record could reflect, she's identified Miss Miles.
All right, the record will reflect that she has identified the defendant.
Did you interview Miss Miles?
I did.
Did you look at Miss Miles' criminal history?
Yes, I did.
Did you document all of that?
I did.
Did you do a strong R assessment for Miss Miles?
Yes.
And is that put together with an investigative report?
Yes, it is.
Did you also get victim impact statements from, I believe, a Miss Sanders
Yes.
and the parents of a child with the initials KO?
Yes.
Your Honor, if I could please pass forward an item.
You may. Pass it to the witness if you would.
You've been handed a document, Officer James. If you could please look at that. If you please ensure that it is your copy. Is it a copy of your document that you had, the pre-sentence report?
Yes.
Okay. Your Honor, I would move to make that state's first exhibit.
All right, you want to make that copy to the exhibit? There is one in the court file as well.
Yes, sir. I have my own copy as well, and I've shown it to Mr. Flanagan.
Right.
I believe in your report you put that Mr. Flanagan was appointed.
Yeah, if that's what it says,
Okay. Would it be possible that he was retained in this case?
it could be possible.
Okay. You have the officer's report in here of what happened on that date. Is that correct?
Yes.
I want to go through specifically starting with, I believe it says in the upper left-hand corner, page 7 of your report. Is that where the criminal history starts for Miss Rebecca Miles?
Yes.
Safe to say that Miss Miles has an extensive history.
Yes.
I believe she has a conviction for public intoxication. Is that correct?
Correct.
Resisting arrest.
Correct.
I believe when I counted them, 16 violations of bond condition. I believe you put them as contempt of legislative committee.
Yes.
9 prior assaults.
Yes.
That would include 7 or 8 of those domestic, correct?
7 domestic. Yes.
Did she have an aggravated assault felony conviction?
Yes.
Did she have a simple assault conviction?
Yes.
I believe you put in there she has 6 violations of probation.
Yes. Correct.
She has an escape charge,
Correct.
and that's a conviction. Actually, I say charge, but these are convictions.
Yes.
This does not include charges that may have been settled or dismissed in settlement, correct?
Correct.
She has 2 failure to appear convictions.
Correct.
So if you include the violation of probation, would it be safe to say about 36 admitted violations of the law?
I have 32 total charges and 6 VOPs.
So that'd be 38 possibly.
Yes.
Now, to be fair, I believe one of those is a due care traffic
Yes,
infraction.
traffic. Mhm.
So not including that, we have about 37 by your count.
Correct.
Does she have a theft? I believe I may have missed a theft conviction.
I believe she does.
Okay. Is it important for defendants to appear in court?
Yes.
And whether it's probation, community corrections, or parole, is it important for them to appear?
It is.
Is it important to abide by the terms of court orders and probation or parole orders?
Yes.
And she has an escape, not abiding by the order, correct?
Correct.
2 failure to appear is not coming to court when ordered to, correct?
Correct.
And when given orders by this court to not have contact or use drugs, have gun, whatever the condition was violated, she's been convicted 16 times of not abiding by those conditions, correct?
Correct.
Let's talk about treatment services. Based on your assessment, did you believe Ms. Miles could be helped by some treatment programs?
I do.
Could that include for her anger issues,
Definitely.
mental health issues,
Yes.
substance abuse?
Yes.
To your knowledge, those services are available at TDOC, correct?
Yes.
Let's talk about your strong R. Did you conduct the strong R assessment with her?
I did.
Now, you note the need for her to address things such as mental health and substance abuse, correct?
Correct.
But in your strong R, those actually came back as low needs. Is that right?
The reason they came back as low needs is because those are being addressed currently in jail.
So I want to get this clear for the record. So while she's in jail, these needs are now low because she is no longer having these needs while incarcerated.
Well, they're being treated.
So it's helping while
So-
she's in jail.
Yes.
Okay. So incarceration, she could be treated while incarcerated.
Yes.
In fact, treated to the point that these are now low on a strong R assessment.
Yes.
In Miss Miles' statement, did she ever mention anything about her gun?
No, she did not, and I did not ask.
She provided a statement about this incident. I believe in your report, she said that her husband had possibly cheated on her and she was going to a hotel room. Is that correct?
Correct.
But she never mentioned, she never offered anything about this firearm.
No.
Okay. One moment, please. Thank you, officer. That's all that I have at this time.
Flanagan, you may cross-examine.
Thank you. Ms. James, you I don't know how many people you've interviewed, a lot. But this kind of jumps out that anger and substance abuse and low self-esteem are her main issues, are they not?
Correct.
No question about it.
No.
And as you indicated, she showed remorse. She was thankful that nothing worse happened to anybody.
She did.
And General Stevens asked you about programs to help her. Those can be addressed and are being addressed in the local jail.
Yes.
So she doesn't have to go to TDOC to get that help.
Correct.
Okay. Let me ask you this, and you're more experienced than I am, and I'm just going to cut to the chase. Do you think she is the candidate to go immediately onto probation?
I do not.
Okay. So you think she's receiving help in jail? Do you think a split confinement would be something to consider for her, to stay in jail to keep getting help?
I do think she needs some rehabilitation before
Yeah.
she goes back into society.
Okay. Okay. All right. Thank you. That's all.
Mr. Stevens.
Officer James, you said that she showed remorse. I want to go through her statement. She said, "What if I had hurt someone?" Correct?
Yes.
So that implies she didn't hurt someone, correct?
It could.
Yeah. Now, you're talking about rehabilitation. You think she needs something to rehabilitate her before she's ever trusted out among everyone else?
I do.
The free world, as they say.
Yes.
Do you think she could be a danger with her anger and substance abuse to everyone else?
I do.
And that can be on the road with a DUI, correct?
Correct.
That can be at home with any of her family members when you have, I believe, almost double-digit convictions for domestic assaults.
Correct.
Nothing further. Thank you.
Flanagan.
You make assessments based on your conversations with people about whether or not she showed remorse, and your opinion is she showed remorse, right?
She did.
Okay.
Nothing further, Your Honor.
All right. Thank you, Mr. James. You may step down. Call your next witness.
State calls Akasha Green, Your Honor.
Screen is still come right around and follow where this bailiff is showing you. We're going to bring you up to the witness stand. Step right up here and raise your right hand and be placed on your oath.
Do you solemnly swear affirm testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
We'll let you pledge allegiance to the flag if we have one. You do it, but we don't. So, thank you. Have a seat, please.
Good afternoon, ma'am.
Good afternoon.
If you could please speak into the microphone so we can record what you're saying.
Yes.
Can you please state and spell your name?
Akasha Green, AKASHA, GREENE.
Miss Green, do you recall an incident on January 22nd, 2025 that brings us to court today?
Yes.
Where were you at when this occurred?
I was driving from White Bluff to Dickson on Highway 70.
Westbound, you think?
Yes.
And what happened while you were, was that in Dickson County? Let me ask that. Was that in Dickson County?
Yes, sir.
What happened while you were driving?
I was behind a vehicle that was driving erratically.
What do you mean by driving erratically?
Swerving in and out of the lane, hitting the brakes, speeding up, just not abiding by the traffic laws.
Did you feel safe?
No.
So what did you do?
I passed them.
Okay. How did you pass them?
I got above 80 speeds and passed them around Catfish Kitchen.
So you had to go over 80 miles an hour to safely get around them?
Yes.
Were you in fear for your own safety being behind this car?
Yes.
And it took 80 miles an hour for you to be able to safely get around them?
Yes.
Was that the last you ever saw of that car?
No.
Okay. What happened?
After we got to the red light, the intersection of 96 and 70, within just seconds of being at the light, there was an impact.
Okay. Where were you? Let me see 1 second. Google Maps one. Can we turn that a little bit this way towards her? There we go. We're figuring out some technical things. 1 second, please. Does this look familiar to you?
Yes,
Okay. And what does this appear to be?
an intersection. It looks like 70 and 96.
And on the right side, I believe, is that a sign saying turn left to go to 96?
Yes,
Okay. Is this the intersection that you were at that day?
yes.
Where would you have been, in the slow lane, the fast lane, or the turn lane?
The fast lane.
And how far back were you?
3 cars.
Did you ever see a school bus that day?
Yes,
Where was it?
it was in the turn lane, the left turn lane.
And what happened?
The light, the green light for the bus to go, came on, and the car that I passed slammed into the back of the bus.
Where would the car that you passed had to be to slam into the bus?
It was in oncoming traffic, going around everyone in the intersection.
Okay. And during that time, it struck the school bus?
Yes,
Would it make sense to say the back left side, perhaps?
yes,
Okay. Did you cooperate with police and give them a statement?
yes.
Now, just for the record, did you ever see who the driver was of that car?
No,
But you gave police a statement as to what happened that day.
yes.
That's all that I have at this time. Thank you.
All right. Mr. Flannery, do you have any questions?
I do not, Judge. Thank you.
Thank you, ma'am. You may step down. You may have a seat in the courtroom, or you may be excused. Mr. Stevens, your next witness.
Yes, sir. State calls Jackson Miller. I believe so, because she seemed to look at it and answer, so I would say yes. I noticed she looked down at it when answering, so I think she can see it.
You solemnly swear affirm testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
That's it.
Good afternoon, sir.
Good afternoon.
Okay, if you can, make sure to speak into the microphone when answering questions. Please try to avoid nodding your head or shaking it. Answer either yes, no, or whatever your answer is. Say it aloud. Sir, please state your name.
Jackson Miller.
How do you spell that?
JACKSONMILLER.
Mr. Miller, what do you do for a living?
I work at Greater Dickson Gas Authority.
Okay. What were you doing? What was your employment January 22nd, 2025?
I was still working there.
Do you remember an incident occurring that day that brings us to court today?
Yes, sir.
Where were you at?
I was sitting at the intersection where it happened.
Okay. What happened? Where was let me back up. I'm sorry. Where was the intersection?
96 and 70.
Which way were you facing?
I was at the red light on 70 facing towards White Bluff.
So you'd be going eastbound.
Yes, sir.
While you were there, what did you see?
So I was sitting at the red light. I was in the passenger seat. I was looking at my phone, and I looked up, and the bus was sitting in the turning lane to turn on 96. And about the time when I looked up, I seen the car coming towards us, and the passenger side had caught the driver's side of the bus, and that's when the wreck occurred.
Did you say anything to your friends or before it occurred?
Yeah, I was like that. The car's about to hit the bus.
Did you see any braking?
No, sir, not that I seen.
Okay. What happened to the bus?
She hit it pretty hard, and then it went up in flames.
In flames. I'm going to show you something. It may be if you can let us know if it's on the monitor in front of you, or if not, that's whenever it comes up. Can you see it on the monitor?
Yes, sir, I can.
Okay. What do we appear to be looking at right here?
So that is the truck that I was sitting in, and that is after the wreck occurred.
Is it okay if I zoom in?
Yes, sir.
Maybe a little blurry, but I'm zooming in. What do we appear to see here?
There's firefighters putting out the bus that's in flames.
That car that's beside it, the red car, does that appear to be the car you saw?
Yes, sir.
Okay. Does that appear to be an accurate depiction of what you saw that day?
Yes, sir.
I can please hand you an item. Sir, does that appear to be a printed copy of the image that you're looking at?
Yes, sir.
Your Honor, state moves to make that state's next numbered exhibit.
I believe this pre-sentence report was made an exhibit, so this would be number 2.
Yes, sir.
Go hand that to me.
Do you believe that red car was driving in a proper manner, obeying the rules of the road?
Not at that location, sir.
What do you think would have happened if she had not struck the bus?
I believe she would have hit us head on.
That's all that I have. Thank you.
Mr. Flanagan?
No questions.
Thank you, sir. You may step down. You may have a seat in the courtroom, or you may leave if you like.
State calls Officer Daniel Lewis.
Raise your right hand, be placed under oath. Solemnly swear affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Have a seat.
Good afternoon, sir.
Good afternoon.
Please state your name.
Daniel Lewis, sir.
Please spell it.
DanielLewis.
Where are you employed?
I'm employed at the Dickson Police Department, sir.
How long have you been in law enforcement total?
In total, 9 years, sir.
Were you in that capacity on January the 22nd, 2025?
Yes, sir.
Who were you with?
I was with the Dickson Police Department Patrol Division.
Do you recognize the defendant in this case? And if you need to move, that's fine.
Yes, sir.
Who is that?
That's Miss Rebecca Miles, sir.
Does she also go by Rebecca Fain based on your investigation?
Yes, sir.
Was there an incident with Miss Miles on that January 22nd, 2025 date that brings us to court?
Yes, sir.
Where did that occur at?
That occurred at the intersection of 70 and 96.
Now, we're in a sentencing hearing, so this is not for the full proof of guilt that's already been established. But very briefly speaking, can you provide a basis of what your witness interviews and investigation provided?
Yes, sir. Miss Miles was traveling westbound on Highway 70 East, striking a bus at the intersection, causing the bus to engulf in flames.
Was that her car?
Yes, sir.
Did she admit to driving?
Yes, sir.
Who was on the bus at the time of the incident?
There was a bus driver and a 6-year-old child.
Okay. Where did they have to go?
They were on the hill going towards the church.
Okay. Was there anything inside of Miss Miles have a purse or any other item in her car?
Yes, sir. She had a purse in the car.
What was inside the purse?
There was a prescription bottle for oxycodone and a purple Ruger pistol.
Who was the oxycodone prescribed to?
To her, sir.
Did you notice anything odd about its counting of the pills?
So it showed that it was filled the same day, and it was supposed to have 120. And when counted, it was 82.5.
So more than a quarter gone?
Yes, sir.
Okay. Did you ultimately get a sample for blood for chemical testing?
Yes, sir.
I'm going to hand you an item, please. If you can please look at that. To your knowledge, was this tested for blood alcohol content?
Yes, sir.
If you could please look at that item. Who is it addressed to in the upper left-hand corner?
To me, sir.
And who is the subject of this matter?
Rebecca Ann Miles, sir.
What does it show? Is this a TBI analysis of the blood?
Yes, sir.
What does it appear to show her BAC to be?
It shows 0.113.
What's the legal limit in the state of Tennessee, to your knowledge?
0.08, sir.
Would this have been collected after the wreck?
Yes, sir.
Okay. Your Honor, state moves to introduce that as the next numbered exhibit. I believe it'd be 3.
Exhibit 3.
If I can hand you another item, please. Who's that addressed to?
To me, sir.
Who's the subject in this matter?
Miss Rebecca Ann Miles.
Does this appear to show a toxicology examination by the TBI?
Yes, sir.
What does it show to be positive or present in her system?
Oxymorphone.
Okay. What does it show the quantitative amount to be?
9 ng over ml.
Nanograms per milliliter?
Yes, sir.
State introduces that as state's next numbered exhibit. I believe it'd be 4, Your Honor.
Hey, what, Daniel, you can just hand them to me.
Yes, sir.
Save him having to work so hard.
Yes, sir.
You said you've been in law enforcement how long?
9 years now, sir.
How old are you?
I am 32.
You've actually been in law enforcement for 32 years, haven't you then?
If you wanna count.
Considering that I have known his father, who was former chief of police and has been in law enforcement since before you were born.
Yes, sir. Since 87, I believe it was.
I think so.
That's about as long as I've been alive. So there you go. Did you ever speak with Miss Miles?
Yes, sir. After the crash, we went up to the hospital and I did get to speak with her.
Okay. Was she coherent?
Yes, sir.
Able to answer questions as to day, time, and things of that nature?
Yes, sir.
She admits drinking?
Yes, sir. Earlier that morning, she stated that she did drink a bottle of vodka.
A bottle of vodka?
Yes, sir.
So not some shots, but a bottle?
Yes, sir.
She admits taking her pain medication?
Yes, sir. That morning as well.
Where did she tell you she was going that day?
She stated she was going to town.
For what?
I believe she was going to go to the store is what she said.
Did she ever say she was in an incident with her husband and need to go to a hotel?
No, sir.
So if she told that's probation, would that be inconsistent with what she told you?
Yes, sir.
Now, the gun that you recovered, what color did you say it was?
It was purple, sir.
And that was in her purse?
Yes, sir.
Along with her medication?
Yes, sir.
Okay. All these events, they occur in Dickson County?
Yes, sir.
And the defendant in this case and the person involved in this investigation, the one driving the car, that was Miss Rebecca Miles?
Yes, sir.
That's all that I have at this time. Thank you.
Mr. Flanagan?
Yes, sir. So what was the blood alcohol point?
0.113.
Okay. So that's really not consistent with drinking a whole bottle of vodka that morning, is it?
No, sir, it's not.
Okay. And the pill count, just because they weren't all in the bottle doesn't mean that they weren't somewhere else.
Correct.
Okay. She didn't take 30 or 40 pills or she would have been dead. You would agree with that? Okay. And she was coherent when you talked to her at the hospital. So
Yes,
she
sir.
wasn't all that impaired, was she?
I couldn't speak on impairment other than what she
Okay.
could tell me.
Okay. So there's no evidence of impairment and she seemed coherent.
Yes, sir. She was
Okay.
coherent.
Okay. All right. You're a much better witness than your dad. Okay. Who I've known longer than you.
All right. Let's clean up a little bit of that. When did she say she had the bottle of vodka?
I believe it was 7:15 that morning.
What time did this incident take place?
3:45. At that point, we were around the hospital around 6 o'clock or so.
So the BAC could make sense. Now, Mr. Flanagan kind of mixed it in and said, so she's not impaired and blah, blah, blah. Did you believe she was impaired?
I'm going to object to his assessment of what I'm saying.
Sustained seems to be a little inaccurate assessment.
Yes, sir. Did he tell you, did he sneak in that he said that she was under the, so she wasn't impaired? Did you say yes to that?
He said I snuck in something.
Yes, sir.
Judge.
I'll
I'm a
reword
little
it.
bit concerned about this.
I'll reword it. I'm sorry.
Sustain the objection.
When you spoke with Mr. Flanagan just now, did he ask you whether or not you thought she was impaired?
Yes, sir.
What did you think at the time of?
I still think she was impaired at the time of the incident.
Now, he's mentioned that she's not impaired and was coherent. Do you remember something along the lines of that?
Yes, sir.
Did you believe that she was under the influence at that time and too impaired to drive?
Yes, sir.
Now, drinking a bottle of vodka, you testified to what time in the morning?
7:15 is what she stated.
And this came out at about 3:45 p.m.?
Yes, sir.
So some time has lapsed. Is that a fair assessment?
Yes, sir.
Okay. Nothing further. Thank you.
Nothing further.
Thank you, Officer Lewis. You may have a seat.
Thank you, sir.
State calls Officer Bridget Smith. Here's your, yeah.
You solemnly swear affirm testimony you give the truth, the whole truth, and nothing but the truth, so help you God. I swear.
Good afternoon, ma'am.
Good afternoon.
State your name.
Bridget Smith,
How do you spell that?
BRIDGET SMITH.
Where are you employed?
City of Dickson Police Department,
How long have you been employed in law enforcement?
4 years.
And just for the record, how many times have you testified at a hearing?
This is my first time.
Okay. Were you in that capacity January 22nd, 2025?
Yes, sir.
Do you recall receiving a call that day regarding a school bus?
Yes, sir.
And can you walk us through that? What happened?
It was dispatched as a crash of 70 and 96. As I was en route, as I'm topping the hill on 70 East, I observed the flames, or not the flames, more like the smoke, the black smoke, stuff like that. I arrived on scene where I then observed a bus fully engulfed in flames that resulted in the crash.
Did you have body camera at that time?
I do.
Okay. If I could please show her footage. Should be. I'll try it again. Let me try this other one. There we go. I believe this is this. Have you seen your body camera?
I have.
Does this appear to be your footage?
Yes, sir.
Okay. I'm going to start at 2 minutes 50 seconds into the video. The timestamp at the top right is 15:49.
Hey, where's everybody at? Okay. Okay.
You appear to be walking quite a bit, so I've frozen it at 15:49, 45 seconds in the upper right-hand corner for the record. What do we appear to see here?
A bus fully engulfed in flames, sir.
Okay. And did you assess ultimately if anyone was inside that bus?
I was not close enough.
Did you speak with other officers?
Later in the video, yes, I did.
Okay. I'll continue to play.
Seatbelt. No, you're good, you're good.
Now I'm pausing here at 15:50:18. Did you ultimately, was the bus ultimately put out by firefighters?
Yes, sir.
Did you ever see the condition it was in when it was
Yes,
finally extinguished?
Yes, sir.
Let me pass an item.
Thank you.
I've handed you a picture. Does this appear an accurate depiction of what you saw that day, the condition of the bus when it was extinguished?
Yes, sir.
Your Honor, state moves to introduce that as state's next numbered exhibit. I'm going to continue to play.
Freezing?
Did you just say it was freezing?
Yes, sir.
Now, currently, is it July 28th today?
Yes, sir.
Is it fair to say it's very hot outside today?
Very.
Not in this courtroom, it's not.
That's
I'm freezing currently.
outside of this courtroom. Would you say it's fair to say it's pretty hot?
Yes, sir.
Okay. Now, with that said, January 22nd, was it cold that day?
Very cold.
Okay. I'm going to continue to play.
Ma'am, your neck hurt. I know you called with her.
I got you.
So pausing it here for the record, 15:51:02. What were you just notified by another officer?
That the other party later determined to be the victim was on top of the hill. It's the entrance and exit of the church.
Okay. Did you walk all the way up the hill?
I absolutely did. Yes, sir.
Okay.
Okay, that's fine. Who had the child? Me. He's in here. All right. I just grabbed him and got him and it's on fire. Hi. You okay? I was bringing him to our other stop. Our other stop is fine. Jay, his mom, and our stop is at 4 o'clock. I'm trying to get a hold of my boss. So I'm
We try and find Miss Gregory. I know we got previous history about 3 more things she's been locked in.
I'm pausing this at 15:52:39. Was the child in this case, was he very talkative to you?
No, sir.
Continue to play.
You okay? Yeah. You are? Do you have your driver's license on you? Yes. Hello? TJ. TJ. But and then the first your head hurt or anything? No. Oh. Okay, Coach Roberts is gonna call me. I'll call you in just a minute, okay? Here, we're gonna see you back in here, okay? It's cold. Have a seat, okay? I'll talk to you in just a second. It's gonna be okay. We're right here behind her. I know. And that car is playing at this. I will. Are you okay? Just shake it up. I would feel better.
Your Honor, may we approach Mr. Flanagan and I?
You may.
For the record, a pause at 15:53:37. We're going to resume.
There's EMS takes 2 hours and little one. Okay, yeah. And I need. Mason, do we have a nurse to paramedics to check out the driver and the child over here? Okay. Where were you guys?
We was just like right behind.
You saw shell happen?
I just seen part of it. Whenever the car just.
10-4, thank you. Okay, you're on the way to come check you in the maybe, okay? What happened? So I was sitting at the light because it was red, so I was waiting for the arrow to turn like I do all the time. He was sitting behind me, and I talked to him on the way because he's the only killing bus, so I was asking about his clothes, and he was talking about his cars that he had at home. And whenever he was talking about that, I just wasn't sitting, I was looking around like and I looked in my mirror and there was fire, so I just grabbed him and jumped out. Was it just you and him in the bus? Yes. Yeah, she just moving right here. That's fine. Right there, my son was I just saw fire and just grabbed him. So you were waiting at the red light? Yes. Waiting for it to turn green, sitting there talking about little boy stuff, little toys. Next thing you know, you were hit. And I was in the middle of the intersection. I went back and I saw fire and I just grabbed him and ran. My phone's still in, well, 114 Tennessee deal. Yeah. That's why. No, that's okay. That's just, I'm glad you guys are okay. Yeah. I worry about his mom not knowing where he's at. That's why I'm trying to get off for somebody. You need a, I don't own in my car.
I'm pausing this at 15:55:30. What would you describe the condition of this bus driver as?
Sheer panic mode, like her adrenaline hasn't dumped yet from what she had been through.
Who does she appear to be concerned about?
About the child and not herself.
I'll continue to play.
And my list that I keep of all the kids I have in the car was in there. Like I always have a list of kids on my bus that I had just checked them all up. 104, 168, 876. I just checked them all up. I'm sorry. What's her name? Who? Your mother. Oh, sorry. Alpha Owens. And she'll be sitting in the Flying J in a blue.
I'll get Jerry to go over there.
Can anybody call the Flying J?
No, well, Jerry, he works in Fairview.
Yeah, that would be easy. But she's in the blue car. She's going to the Flying J sign. She's parked in there. And your nose. Oh, do your mouth. You're okay. I'm very grateful that you're not maybe okay. Hey, let it out. Okay? That is, you can't see you. Okay? Anything, come here. Let it out. That's very traumatic, very scary. You were just very grateful, good boy. And you saved that mother's child. Glad both of you are okay and not harmed.
My husband's gonna, he works for Fairview, he's gonna get an officer to go over there. What's the mom's name?
Alva.
Owen, what's her name?
A blue SUV. It's like a little blue car. It kind of looks like a, what is that new car? Like a, what is it, Tesla maybe? Oh, is it supposed to be parked somewhere, sir? Yes, when you pull into the door to the right, underneath the Flying J side. She's the only one that'll be open. I just can't stop shaking. You did a good job. Thank you. I just did an amazing job. You didn't even have time to think, you just did it. And that's what's wonderful, because a lot of people are pros. Can I hug you? Absolutely.
All right, I'm stopping this at 15:57:45. Is all of this an accurate copy of your body camera that day?
Yes, sir.
Were you able to see the mental condition, mental state of the bus driver?
Yes. Yes, sir.
Did this appear to have affected her?
Absolutely. It would have affected anybody.
Okay. Thank you, officer. That's all that I have.
Questions, Mr. Flanagan?
Did you say this is the first time she's ever testified? Sorry. I don't want to be the first cross-examiner. I don't have any questions.
All right, thank you, ma'am. You may step down and have a seat in the courtroom if you'd like.
State calls Libby Sanders.
You'll raise your right hand, please.
You solemnly swear affirm testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Good afternoon, ma'am.
Good afternoon.
If you can, please speak into the microphone so we can record what you're saying. Try to avoid shaking your head and nodding. Just answer with verbal answers, okay?
Okay.
Please state and spell your name.
Elizabeth Sanders, ELIZABETHSANDERS.
Do you go by Libby?
I do.
Libby?
Yes.
Okay. Ms. Sanders, how do you feel today, right now?
Kind of all over the place, to be honest.
You feel a little nervous?
Yes.
Okay. Well, I'm going to ask you some questions. Are you a bus driver?
Yes.
Who are you a bus driver for?
Nashville Christian School.
Were you a bus driver for them in January 22nd of 2025?
Yes.
Do you recall an incident happening that day that brings us to court?
Yes.
If you could, I'd like to ask you about right before the incident, did a wreck happen? Let me ask you that.
Yes.
Right before the wreck, what were you doing?
I was sitting at an intersection waiting for the green arrow, and I was talking to one of my school kids.
Okay. That's fine. I didn't want it for Mr. Flanagan to be in his way. I'm going to show you a picture if I can. me leaving it here, leaving my computer here. It's about to be in your way. Does this intersection look familiar, ma'am?
Yes.
Is that the intersection that you were at that day?
Yes, sir.
Is that the intersection of Highway 70 and 96?
Yes, sir.
What county is that in?
Dickson County.
So where would you be in this picture?
The left lane, the left turning lane.
To turn left onto Highway 96?
Yes, sir.
Who was in the bus with you that day?
Christopher Owens.
Okay. How old is he?
He was in first grade.
Possibly about 6,
Yes.
but less than 9 years old. Is that fair to say?
Yes.
What was he talking to you about?
We were talking. I was trying to keep him awake so he wasn't asleep when he got to his next bus stop, as he usually does. And I was talking to him about his favorite cars, and I asked him, "What is your favorite car?" And he told me it was a yellow Bugatti. And I still to that day think that's a little funny for a first grader. But that's what we were talking about.
Seems to have a little knowledge about vehicles.
He does.
Was Christopher talkative?
Yes.
What happened while you were there? What happened?
So when he said that, I kind of laughed, and we were still waiting on the green arrow. So I kind of looked back at him and smiled at him, and then I felt like I got pushed, and I looked up, and we were in the intersection, and I looked in the mirror on my left side, and I saw flames up the side of the bus.
Do you think the bus was on fire at that point?
Absolutely.
So what did you do?
I turned to look at Chris, and I told him to come here, and I grabbed him, and I saw my purse right next to him. So I just grabbed them both and ran up the hill at the First Baptist.
Did you have a cell phone?
Yes.
What happened to it?
It burned in the bus.
You know, cell phones are almost part of our body now that we take everywhere with us. But did you even have time to grab a cell phone in this case?
No, and I always sit on it like it's under my hip for emergencies. And I wasn't thinking about it at all.
Okay. What would have happened if you had been on the bus longer?
Oh, I feel like we would have died. It went up really quick.
Okay. Was it a total loss to the bus completely engulfed in flames?
Yes, there was nothing left.
Okay. Did you talk to officers on scene?
Yes.
I want to talk about, did you fill out a victim statement in this case?
Yes.
Going through that, did you go back to work the next day?
No.
How long did you take off work?
Till I think Monday or Tuesday of the following week.
Was that as a result of this crash?
Yes.
Did you still feel safe driving at that point?
I was much more aware, but I was told Chris didn't want to ride the bus unless I was there, and so I wanted to be there for him.
So did you drive the bus for Chris?
I did.
Talk about your route. When you take a route to get to places, did that change after this day?
Yes.
What changed?
I used to go out the side entrance by Greystone, and I would turn in that turning lane to wait for the green arrow to turn, because I thought that was the safest route to go. But I can't do that anymore. I now go all the way in front of the church and all the way around, and I'll sit at that the other side of the light. And before I go, I look at least 4, sometimes 6 times before crossing.
Does that have a long-lasting impact on you?
Yes.
Are you anxious when you approach that intersection now?
Yes, but I don't let the kids see that.
Okay, so you're hiding it for the kids?
Yes. Because they still talk about it.
We'll talk about the crash.
They do.
I'll talk about Chris. Has he changed since this incident?
Yes.
How's he changed?
He doesn't fall asleep hardly at all anymore. It's rare. And I had changed my bus seating. He used to sit, well, he does sit behind me now, but there was baseball bags and softball bags coming through, and I saw that they were hitting the little ones. And so I was like, I'm going to clear a space out on the seat behind me so y'all can sit y'all stuff there. It's not hitting anybody. Well, Chris didn't like that because that was his seat. And he came to me and he was like, can I please have my seat? He said, I need to sit there. And I moved it, and I made sure that he's able to sit behind me. He doesn't want to sit anywhere else but behind me.
Okay. Did you ever offer him to move a row or two back to be with a friend?
Yes, and
I
he
believe
refuses.
he refuses. I believe you put that in your statement.
Yes.
Okay. What long-term effects has this had on you?
I just I do have anxiety medication, but it's not as bad. The week or two after it happened, my eyes were twitching for a while from the stress, and I just I noticed I always check my mirrors. I'm really good about that, but I feel like I check my rear view mirrors a whole lot more.
Now, the judge today has some decisions to make that include the length of service of whatever the sentence is between 8 to 12 years, and ultimately whether this involves a full probation or part probation. Do you think probation should be given in this case?
No,
What would you like to see happen in this case?
the max sentence. I don't want this to ever happen again or to anybody because it could have been so much worse. And the what ifs play in my head all the time.
Okay. Do you think she'd be a danger driving around with others?
Absolutely.
Okay. Is there anything else you'd like the judge to know in this case?
So my bus students, to this day, they still talk about the bus fire and the bus crash because some of them were around when it happened because I had just let off my bus kids at the First Baptist. And so their parents were driving around them. And I have to tell them to change the subject because it makes Chris very uncomfortable, and you can tell he gets very silent and very reclusive. And so I think it's had an effect on a lot of my smaller bus children, and I just feel like she's a danger.
Thank you. That's all that I have.
No
Any
questions. Thank you, ma'am. You may sit down.
Stay calls, Ms. Owens. Good on time.
Maybe if you'll step right around here. You'll raise your right hand and face our court to my right. Please, ma'am. Hey, stand right up. A little bit of an awkward situation.
Do you solemnly swear or affirm testimony to give me the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good afternoon, ma'am.
Hello.
If you could please speak into the microphone, speak clearly. Try to avoid shaking or nodding your head. Answer aloud. Please state and spell your name.
Alva, A-L-V as in Victor A, last name Owens, O-W-E-N-S.
Miss Owens, do you know a Christopher Owens?
Yes,
Who is he?
he is my son.
Do you recall an incident about January 22nd, 2025 that brings us to court today?
Yes,
Okay. How old was he that day?
he was 6.
Miss Owens,
No,
let me
wait.
just,
Yes, he was 6, going to turn 7.
okay. Miss Owens, let me just ask you, how are you feeling right now?
A little shaken up.
Okay. I want to go back to that day and ask you a few questions about that day and then what's happened since. Where were you that day when you first heard about an incident?
I was sitting at the Flying J, which is where his bus stop was in Fairview, waiting on Miss Libby to drop him off.
Did she drop him off?
She did not. I started getting concerned because Miss Libby is very prompt, and she may be at the most 1 minute late. But I try not to panic. After about 10 to 15 minutes, I started to panic a little. I'm like, okay, maybe there was a parent that was running late at the previous stop. So I didn't worry. 20 minutes in, Miss Libby normally sends a text if she's ever going to be late. I didn't get a text message. So I called my husband and said the bus wasn't there yet. Again, I tried to wait out a little bit longer. Soon after, I got a call from Miss Brazel. At the same time, a Fairview police officer was pulling up next to my car asking me, was I Alva Owens?
Who is Miss Brazel?
She is the head of the lower school at Nashville Christian.
So you're sitting here waiting for your child, and an officer comes up to you,
Yes.
and what happens?
I rolled out my window and he asked me to verify who I was. He informed me there had been an accident and that I needed to go to, it was a church in Dickson. At the same time, I'm answering the call and Ms. Brazel is confirming the same information.
Okay. And describe what kind of a child was Chris before this date?
He was a very daring child, a typical boy, jumping
Okay.
off of everything.
Jumping off of everything.
Yes.
Did he take risks?
Oh, yes. Christopher actually fractured his face in kindergarten because he was using the tables as parallel bars.
Okay. All American boy. Is that
All
safe
American
to say?
boys.
Okay. And this day, was Christopher involved in an accident to your knowledge?
He was riding the bus Miss Libby was driving.
Now, just for the record, you weren't there at the scene, correct?
I was not.
Did you notice anything about if Christopher was quiet? Would that be odd?
Very odd.
How's he been since this day?
He is very reserved now. He's clingy. He doesn't want to leave our side a lot. He's more reserved. He's afraid of fire. When we had to freeze the snow and ice this winter, our power went out and we lit our fireplace for the first time. He did not want to be around the fireplace. We had to calm him down and then explain that there was only source of heat we had at the time. But
Did he ever tell you about his concern about what he watched for the fire?
yes,
What happened?
he had a flashback about the fire on the bus. It took Christopher a while to talk to us, though. He did not want to relive that. Actually, before I heard the whole story, he was talking to a friend that doesn't go to his school that we had invited over to the house for a play date. And I overheard him telling the little friend I was in an accident and that his bus caught on fire and Miss Libby lost all her stuff and he lost his backpack, and that he was scared and but actually he never would completely open up to us. It was another 6-year-old that he opened up to.
Is it safe to say that this has changed him?
It has. It has.
And did you give a victim impact statement to the probation officer?
I did.
Okay. Everything in that correct to the best of your knowledge?
Yes.
Now, the court in this case has some decisions that will be made. Are you aware that Miss Miles faces anywhere from 8 to 12 years?
Yes.
And that could be probation, partial probation, or to serve in the Tennessee Department of Corrections.
Yes.
What are you wanting to see happen in this case?
To serve her full time in the Tennessee Department of Corrections.
Would that be 12 years when you say full time?
The full 12 years. I don't want another parent or anyone to have to go through this. This has impacted not just my family, Miss Libby's family, the whole Nashville Christian family, because there were other kids that witnessed that accident.
Okay. Is there anything else you'd like to tell the judge?
I'm here today because I love my child. I want to protect him, and I don't want any other parent to have to sit here in front of you to experience this again.
Thank you.
Mr. Flanagan?
No questions. Thank
you. So, you can sit down. You can have a seat in the courtroom if you like.
State's final witness be Mr. Owens.
Step right around here, raise your right hand, and place on your oath. towards me.
You solemnly swear affirm the testimony here will be the truth, the whole truth, and nothing but the truth, self you got.
Yes. Thank you. Have a seat.
Good afternoon, sir.
Afternoon.
If you can, please speak clearly into the microphone. Try to avoid shaking or nodding your head.
All right.
And answer aloud. Please state and spell your name.
It's Christopher Owens, Kristopher. Last name Owens, Owens.
Is there another Christopher Owens in your family?
Yes.
Who is that?
My son.
How old is he?
He's now 8.
How old was he? How old was he on January 22nd, 2025?
6.
Do you recall an incident occurring that day that brings us to court?
Yes, sir.
Now, I want to talk about Chris before this incident. Can you describe your son for me?
Oh, absolutely. Prior to the incident, he was a bright, outgoing, lovable young man that he was a child that everybody loved. You could say that he was almost mayoral in character. Loved to be around people, kind of shaking hands and kissing babies. Personality, kind of life of the party. Didn't meet a stranger. Just was kind-hearted individual.
Would it be odd for him to have been quiet at that time?
Yes.
Do you recall an incident happening involving a crash January 22nd, 2025 with your son?
Unfortunately, I can't forget it. It was a day that changed my son, who went from being the life of the party, outgoing, to now being reserved and withdrawn, in a state of our fear almost. There was, or it still remains, seeing the thing that you're supposed to be safe in, which is the bus, experiencing an accident where the bus catches on fire. And at that age, their belongings are not just stuff like we characterize things as adults. Their belongings mean something to them.
Did something happen to his belongings that day?
Unfortunately, yes. His belongings perished with the bus. And he saw the bus go up and he was worried about his brand new backpack that he just got, his new water bottle. Those were things in the work that was inside because of school. Those are things that he worried about, and it still does.
Is he, as you talked to him, as mayoral, shaking hands, kissing babies? Is he that way now?
Not as much, no.
What differences do you see?
He is much more reserved, much quieter, almost saddened in his personality now. There was lots of fear when it came to riding the bus again.
Does he still like riding the bus?
He finds comfort in the bus driver because, she saved him. And so he finds comfort there. But it took a lot of parenting and counseling and coaching to get him to the point where he was willing to get back on the bus or be by a bus.
Do you think this has had an emotional toll on him, to say the least?
Absolutely.
The judge in this case today has decisions to make, and he can decide anywhere between an 8 to 12 year sentence length, and he can decide the manner, whether it be full probation, part probation, or to serve the sentence. What do you want to see happen today?
12 years in prison. Decisions were made that day that not only impacted my child, and we don't know what that long-term impact is going to be, but it also impacted so many other people that have to live with the memory and the thought of a bus being on fire that had people on there. It's every parent's worst nightmare, every first responder's worst nightmare to come to a crime scene that has children involved, and especially children on a bus. Children are our future. They hold a spot in our heart. They're what we look at as hope. And when you have to walk up on that and do your job, or if you have to experience that, that leaves an indelible mark that will always be there. Some people are able to move past it. Some people aren't. It is definitely for something that thankfully or could have been prevented. We're thankful that it was handled in the way that it was handled, and everybody did an amazing job responding to the incident. However, because the decisions were made that day to get in the vehicle and drive it inebriated under the influence, that could have changed what our statement is today, because our son, to whom we love dearly more than anything else, could not be here today.
Is there anything else you'd like the judge to know?
It's been difficult on all of us, as you can imagine. Decision making is a skill. I pray and I hope that she no longer has the ability to impact families or first responders or small children again in the near future, and that she has the opportunity to understand how much of an impact that this has caused on our family. You go from a little boy that sees the world as amazing and large and is curious to a scared young man, a scared little boy who no longer has that wonder in his eye, because he knows now that not only do bad things happen, but bad things could happen to him. And as a father, my job is to protect my child, and not being able to do that hurts. And I don't want any other fathers or mothers to be in a position where they can't protect their children because of bad decisions.
Thank you. That's all I have.
No questions.
Thank you, Mr. Owens. You may sit down.
That's the state's proof, Your Honor.
State has rested. Mr. Flanagan, do you wish to offer proof?
No proof other than a statement in allocution.
All right. If your client wishes to come to the
Entitled
podium,
to make a statement. Ms. Miles.
if she's going to take the witness stand. then
No,
I guess-
she can do it at the podium since it's an allocution. She won't be under oath and won't be cross-examined. So you're free to make a statement, ma'am.
Okay. I'd like to begin with expressing my deepest, sincerest apologies to the families that were impacted and victimized that day on the bus. I truly am sorry. I thank God every day. Not a day goes by that I'm not grateful that I'm the only one that got physically hurt that day. Because I wouldn't have been able to handle it if I hurt someone else because of my negligence that day, let alone the child. I tried to make the best of my time here. It's been a long 10.5 months, but I've tried to make the best of my time here. I've taken anger management classes and graduated 2 of them. I've taken and graduated 2 domestic assault classes. I've gotten baptized, and I attend an AA program every week since October. And if just given the chance, I'd like to get out and continue my program. That's first and foremost, will be my sobriety. That's important, working a program and doing my meetings and getting a sponsor and being accountable for my actions. I don't know what else to say or how I can express how sorry I am to you all. That y'all had to go through that your children had to go through that. I made bad decisions that day, sir. Yes, you were right. And they're decisions I got to live with for the rest of my life. And I'm sorry. That's it, Your Honor.
Anything further?
No, sir.
Okay, you may have a seat. Otherwise, no proof. Just argue.
All right. Mr. Stevens, you may argue your case.
Your Honor, when we go to 4035-102, the purpose of incarceration, we go through some factors. Punishment shall be imposed to prevent crime and promote respect for the law by providing an effective general deterrent to those likely to violate the criminal laws of this state. Part B, restraining defendants with a lengthy history of criminal conduct. I'd like to start going through this TCA. The legislative intent is clear. We have Ms. Miles, who has, when you add these 4 new convictions, 40 convictions in her life. You heard from probation today about all those convictions. I believe it was more than double digit on not abiding by court orders with conditions of release with domestic assault. I believe it was 9 total assaultive offenses, 7 of those, 6 or 7 being domestic in nature. And she's a convicted violent offender with aggravated assault. She's been given chances before to abide by the terms of probation. You saw how many convictions she's had for that, how many VOPs, more than a handful. Ms. Miles has a history showing that she's a danger to others. When you go to the enhancement factors, 4035-114, you can look at number 1, and I don't think we could be any clearer on this. The defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. She has a substantial criminal history. Factor 3, the offense involved more than one victim. We have Ms. Sanders, Ms. Libby Sanders, and we have the child, Chris. Number 4, a victim of the offense was particularly vulnerable because of the age or physical or mental disability. We have a 6-year-old. Factor 9, the defendant possessed or employed a firearm, so in this case possessed, during the commission of the offense. When this bus was hit, she had a gun in her purse. So I think that would go towards the reckless endangerment at least, and towards the child endangerment. Now, Your Honor, let's say there was no crash that day. Let's say this was simply speeding, being pulled over for going 10, 15 miles per hour over. And then they go through your purse, you let them have a search, and they find in your purse a gun, and you're a convicted felon with a B felony or the prior violent felony. That in and of itself is age 12 years. And it's at 85% under 4035-501. I believe it's subsection Y for the gun. That in and of itself, having that gun in her purse, along with her prescription medication, is age 12 years at 85% by itself. But we don't have just that. We have a person who has consumed alcohol, a substantial amount earlier in the day, where ultimately she's still a 0.113 at the time of this accident. She goes around, is driving recklessly, putting other citizens at fear. Citizens who you heard from one today, Ms. Green, saying she had to go over 80 miles an hour to safely get around her so that she was not hit, because she didn't want to be nearby her. She was driving erratically, braking, scaring her. So Ms. Green goes ahead and goes up to this intersection, and across the street's Mr. Miller, sitting with his coworkers, going through his phone where he says this car's about to hit this bus. And he said that if she had not hit them, she was projected to go straight on, head on into him. She hits the school bus, ignites it on the driver's side. It catches fire. I think it's safe to say this traumatized driver has to grab this child, leave her phone, leave her possessions, whatever she cannot get, and run for the hill, literally and figuratively. Having to run up this hill towards this church, taking a little 6-year-old who has gone from being fearless using tables as little bars to jump around with, not fearful of anything, and the talk of the town, wanting to talk to everyone, and scaring him. You saw the video. He gets out of that car and he doesn't even want to look at Officer Smith. He won't say anything. He'll just nod and maybe say a couple of words the entire video. It's had a long-lasting impact on him. The ice storm came through this year. You heard testimony that he now looks at that and he's afraid of fire. He's afraid of what can happen and whether this can hurt him. As his dad said, little toys and items to children are not just a backpack. That's your personal item. That's something you cherish. And he has memories of it being set on fire and burning in front of him. She's been convicted of negligently by act or omission, placing a child at risk of serious injury. It's a misdemeanor unless the child's under 9, which we have a 6-year-old here. And that makes it a B felony, age 12 years. That under 4035-501 is a 100% sentence. People are impacted by this. I pointed out during questioning that in Exhibit 1, she said, "I'm just glad no one was hurt." Well, I submit to the court that people were hurt. It may not be a bump. It may not be a scar in a physical, but it's a mental one. We have Ms. Sanders, who's permanently hurt by this. She's the victim of the reckless endangerment. We have Chris, who's permanently hurt by this. He's the victim of the child endangerment. She's under the influence, DUI. And then on top of all of that, a completely separate action in her purse is a gun that she should never have. She's a violent offender. That gun alone is worth 8 to 12 years at 85%. The state believes the right action in this case is to have Ms. Miles continue any treatment she has while incarcerated and ultimately to be sentenced to 12 years to serve in the Tennessee Department of Corrections in accordance with 4035-501 with the sentences, Your Honor. Thank you.
Mr. Flanagan.
Thank you, Judge. This could have been a completely different sentence. Thank goodness it's not. We can talk about all of the factors. The court can look at mitigating and enhancing factors, but I do so much appellate work on these sentencing issues that it usually comes down to 4035-103, which requires that the sentence imposed must be the least severe measure necessary to achieve the specific purposes of the sentencing law. So that's what it comes down to. What's the least restrictive? It's mandatory. The court has to find the least restrictive. She's shown remorse. That was the proof. We know what her issues are: anger management, substance abuse. The testimony is that those are being addressed where she is in the jail to the extent that she is a low risk. I don't think, and I respectfully submit, that a prison sentence under the facts of this case is not the least restrictive. This is, in the normal sense, not an intentional crime. Like I usually have murder cases or child sex cases. The result was not intended like we usually have in some cases. So, you could argue, well, it's intentional because she drank and then she drove. In that sense, I agree, but it's not result intentional. She didn't intend for the result. So it's a little bit different. And she has an extensive record that would justify not giving her full probation. But I think the least restrictive measure would be an alternative sentence of split confinement. She's been in custody for 10 months. The court could sentence her to 8 years with another year to serve in split confinement. The issues that she has will be addressed in the jail because they are now. And they're obviously working because she's now at a low risk. So I don't think a prison sentence under all the facts and circumstances of this case is supported by the evidence.
I may have a brief rebuttal. Your Honor, going to that exact TCA, sentences involving confinement should be based on the following considerations. A, necessary to protect society by restraining a defendant who has a long history of criminal conduct. That's absolutely met here. Absolutely. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. This is someone who's a convicted felon carrying a gun, and it's also someone who has committed child endangerment by driving impaired and putting as well reckless endangerment of a bus driver. And then finally, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. I believe I asked Ms. James, and she said that there were 6 violations of probation. So we have a frequency of less restrictive means being applied, and they're not successful. I believe that all 3 of these factors under 4035-103, 1, weigh in favor of the state, and they encourage incarceration to not depreciate the value of this, to ultimately have Ms. Miles incarcerated to protect others. And we've seen that violations of probation, she has 6. It doesn't work. Thank you.
Anytime that I'm required to impose a sentence at a sentencing hearing, I'm required to follow the guidelines that our state legislature has set forth. I cannot just randomly select a number. I'm required to make findings according to the sentencing laws of the state of Tennessee. Mr. Stevens and Mr. Flanagan have both made references to portions of that statute that I'm required to follow. And in keeping with what I do in almost every sentencing hearing, the court will refer to those sentencing guidelines in making this decision. 4035-102 sets forth the purposes of this chapter of the sentencing law. The foremost purposes of this chapter is to promote justice as manifested by 4035-103, and in so doing, the following principles are adopted. 1, every defendant shall be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. This chapter is to assure fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing and providing a fair sense of predictability of the criminal law and its sanctions. 3, punishment shall be imposed to prevent crime and promote respect for the law by A, providing an effective general deterrent to those likely to violate the criminal laws of the state. B, restraining defendants with a lengthy history of criminal conduct. C, encouraging effective rehabilitation of those defendants where reasonably feasible by promoting the use of alternative sentencing and correctional programs that elicit voluntary cooperation of defendants. And D, encouraging restitution to victims where appropriate. Sentences, number 4, sentences should exclude all considerations respecting race, gender, creed, religion, national origin, and social status of the individual. Goes on to talk about other factors, but those are the principles that generally have to be applied. Then 4035-103, as both have cited, to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. C, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. 2, the sentence imposed should be no greater than that deserved for the offense committed. 3, inequalities in sentences that are unrelated to the purpose of this chapter should be avoided. And as Mr. Flanagan pointed out, 4th, the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. 5, the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or length of sentence to be imposed. The length of term of probation may reflect the length of a treatment or rehabilitation program in which the participation is conditioned of a sentence. And it goes on to say trial judges are encouraged to use alternatives to incarceration, which include requirements of reparation, victim compensation, community service, or all of these. In this particular situation, we have an agreement. There was a 10-count indictment that had been brought against Ms. Miles, citing a number of different offenses. On the 26th day of May of this year, she entered a plea to 4 of those counts, as I previously stated at the beginning. Count 2, count 4, count 6, and count 8. Counts 1, 3, 5, 7, 9, and 10 were dismissed as a part of this agreement. So in one respect, the plea agreement has already afforded Ms. Miles some consideration and some leniency in dismissing some of those charges that might otherwise have been found guilty of. The court would also point out that in 4035-115 provides the following regarding multiple convictions. If a defendant convicted of more than one criminal offense, the court shall order sentences to run consecutively or concurrently as provided by the criteria in this section. Subsection B, the court may order sentences to run consecutively if the court finds by a preponderance of the evidence that 1, the defendant is a professional criminal who has knowingly devoted the defendant's life to criminal acts or as a major source of livelihood. 2, the defendant is an offender whose record of criminal activity is extensive. Clearly, this 40-some-odd conviction would indicate to me that this would be a criminal who is a defendant who has a record of criminal activity that is extensive. Now, why do I bring that out? Because the plea agreement that was entered in this case is, again, a part of the consideration given to Ms. Miles by both the state, her lawyer's effective representation of her, and by consideration of the state and the victims in this case, agreed that her sentences would not run consecutively. I would not even be given that option, that they would be run concurrently. I am bound by that agreement, and therefore the sentence running consecutively, which could have been done in this case, will not be a consideration that this court can impose. So in one respect, it could be said that Ms. Miles has been given 2 opportunities, 2 advantages in this case that she might not otherwise have received if the matter had just gone to trial and she had been convicted or she had pled to all of the counts, because the court could have imposed consecutive sentences in addition to all of the other charges. So determining the sentence that's to be imposed, we'll start with count 2. Driving under the influence, first offense, is a Class A misdemeanor, and this court finds that the maximum sentence should be imposed. I think she's probably already served it anyway. So she is sentenced to 11 months and 29 days in the county jail, ordered to pay a $350 fine and costs of sentence. Her license to drive is suspended for 1 year. And I think I said a $350 fine. The other sentences, Class E felony carries a range of 1 to 2 years. On a range, and I do find that part of this agreement was also that she would be classified as a range 1 offender, and so that is the range of which she will be sentenced. A Class E felony carries a range of 1 to 2 years. A Class B felony, as has been cited again and again, carries a sentence of 8 to 12 years in prison. So to determine what sentence she should receive, the range of that sentence, the court must look to the enhancement factors and the mitigating factors, if any, apply. 4035-114 sets forth the statutory enhancement factors that the court must consider. The court has previously, after reading the pre-sentence report and the factual basis, looked at these factors and then listened carefully to the evidence in this case. And this court makes the following findings as to the enhancement factors. First enhancement factor is that the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range court finds that to be a factor that does apply as an enhancement. Number 2 was the defendant was a leader in a criminal offense involving 2 or more criminal actors, does not apply. Number 3, the offense involved more than one victim, and clearly the court does find that there was more than one victim involved, both the bus driver as well as the Ms. Sanders, as well as Mr. Owens, would be considered by this court to be victims. So number 3 would apply as well. Number 4, the victim of the offense was particularly vulnerable because of age or physical or mental disability. Clearly, that factor also applies because Chris Owens was 6 years old at the time, and I think there's no doubt that he was vulnerable, and all you had to do is watch the video to see his behavior after this accident to know how affected he was. And listening to his parents' testimony, it clearly shows that there was a great deal of effect on him. Number 8 is a factor that sets forth the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community. And that is a factor that this court finds, in my opinion, at least should apply because, as was pointed out, she has been sentenced, convicted of some 38 or 40 convictions. And of those, she was placed on probation and had 6 different violations of probation. So I do think that that was a situation where she failed to comply with the conditions of the sentence, obviously. Number 9, the defendant possessed or employed a firearm or explosive device or other deadly weapon during the commission of the offense. I do not find that to apply, even though I understand Mr. Stevens' argument that the possession of the handgun in her purse was illegal, and it clearly was being held by her in that purse, but it was not, in this court's opinion, actually employed during the commission of the offense. Had she used the weapon in some fashion, that would have been employing it. So I found that not to apply. So I have found that 4 of the enhancement provisions apply to this case. Mitigating factors, the court will go through those. The defendant's criminal conduct neither caused nor threatened serious bodily injury. Clearly, her conduct in this case threatened serious bodily injury to both of the victims in this case. Number 2, the defendant acted under strong provocation, does not apply. Substantial grounds exist tending to excuse or justify criminal conduct, though they fail to establish a defense. I have no evidence before me that would apply that in mitigation. The defendant played a minor role, does not apply. I do not find that there was any other mitigating factor other than you can make argument that the defendant was suffering from a mental or physical condition that reduced her culpability because of what's been said of her alcohol or drug addiction or whatever, but that's really not a defense. And I do not find that any of the mitigating factors apply in this case. So in this court's opinion, as Mr. Flanagan pointed out, we could be here on a very different situation than what we are. What I think about is Miss Sanders testifying about the fact that she had just let off a busload of children at the First Baptist Church right up the hill from that. Had she not let off that busload of children at the top of that hill before this wreck occurred, there was no way that all those children would have gotten out of that bus when it was on fire. And we would have had multiple deaths of children resulting from Miss Sanders' decision to drive that morning after she had ingested substantial amounts of alcohol and drugs. As a result of that, this court is of the opinion that a sentence of 12 years on count 6, which is child endangerment, is the appropriate sentence. On count 8, I find that the Class B felony in that case, that a sentence of 10 years for possession of the firearm would be appropriate. On count 4, I find a reckless endangerment, a sentence of 2 years would be appropriate. All of those sentences will run concurrently by agreement of the parties. So effectively, she is receiving a 12-year sentence on count 6, a 10-year sentence on count 8, a 2-year sentence on count 4, and 1129 on count 2. I have considered whether or not this would be a case that would be appropriate to allow Ms. Miles to have some sort of split confinement. And had she had 1 or 2 prior convictions, I might consider that. But when you have 40 plus convictions, 6 violations of probation, an escape charge, failure to appear charges, aggravated assault charges, domestic violence charges, I think there were like 4 or 5 of those in your prior record. It is this court's opinion that you pose a threat of danger to the community as a whole. And as a result of that, you must be confined to the maximum I can give you, and I'm sentencing you to 12 years in the Tennessee Department of Corrections. That is the judgment of the court for this case. Anything further before we adjourn?
Just for the record, it's 12 years at 30% per the agreement.
That is correct.
It's 100%. We said that on the record.
No, it is.
It's 40-30 for the child endangerment. It's 40-35-501. It is 100%. The gun is the firearm is 85% under 40-35-501Y.
The 100% is the one, the child endangerment. That's the one that she's received the 12-year sentence.
We had that on the plea petition. We said that when we pled her in May, and it's 100%. It's 30% on count 4. It's 100% on 6, and it's 100 down to 85% for the TCA on 8.
Right. That's the process. That's the judgment of the court. So this court now stands adjourned.
Thank you. Your Honor, I'm providing a late tender to discovery just for the video. If we can do
Mr.
that.
Stevens, you had brought the court file, so I'm going to hand that back to you to return to the clerk, please. Or if you're not going to be, I'm sorry, I've got to be there tomorrow, so I can return it.
Thank you.
All right, we stand adjourned.
All right.
Hold on.